Uh, I'm on behalf of S. Bora Lordship. He has some personal difficulty, Lordship. Request me to pray for fixing the meter at series meter.
What is that?
1 to 42 at 2 p.m. Lordship. S. Bora has some personal difficulty, Lordship.
This is for implement of party, isn't it?
There was a direction to file affidavit, Lordship.
Have you filed your affidavit?
He knows, Lordship.
As Bora was.
So he prayed.
Lordship, there are a couple of issues here. We are for the employees who are, and if Lordship will see Lordship's order of 2nd of August 2022, Lordship's own order. These people basically are not getting their salary since 2015. So this affidavit, they may file or not file is on a different point. But at least with respect to the release of salaries of people who are working since 2015 without salaries, that aspect needs to be adjudicated today.
And then what is this item one? This is for implement of this in IA file.
Yes, that matter was heard last time. In fact, if Lordship will see last time's order.
Last order, madam.
Last order.
Last order.
This is order dated 14/5/2024.
The PTC was directed to file an affidavit.
That direction should not stay.
Yes.
So therefore, Lordship, this may not stand in the way. If they want a matter at 2, that's okay. We have no.
PM Lordship. He will come.
I'm good.
Item 1 to
1 to 42.
42.
Grateful.
May I please, Your Lordship? Your Lordship, with due consent of the other side, Your Lordship, I beg to mention item number 51 to 53, Your Lordship.
51.
51 to 53 of daily list, Your Lordship. Your Lordship, my senior, Mr. K. N. Chaudhary, appears in this matter and he was out of station and he arrived late at last night, Your Lordship. So he couldn't prepare the case. Kindly adjourn the matter, Your Lordship.
When do you want?
A short date, Your Lordship. We have some urgency.
Okay, on request made on behalf of Mr. K. Chaudhary, the National Council for the petitioner in WBC 211 of 2024.
24.
List after 1 week.
A date may be fixed, Your Lordship, a short date.
You on a short date.
Can I calculate on a fixed date, madam, because I have also some interest, madam, because of the pendency of this petition. I am not getting the salary for which I am reading, my lord.
13.
13. Your Lordship, there's an interim order that may be continued. Your Lordship.
Interim order passed in.
WBC 211 of 2024, Your Lordship.
211 of. Continue till the next meeting.
Deeply obliged, Your Lordship.
May it please, my lord. Prayer for listing of a matter for tomorrow, my lord. Enquiry report was called for by my lord, my lord. In this matter, my pension was withheld. Well, for tomorrow, my lord, kindly.
Tomorrow there's some problem. We'll have it on 12th.
May I please, Your Lordship, I recommend someone listing the matter on Wednesday, my lord.
Okay.
On list, Lordship.
May I please, Your Lordship? Lordship, I beg to mention for listing of a contempt matter next week.
19th.
Much appreciated.
Item 43 of daily list. admitted part of it.
My pleasure, Lordship. Lordship, the conducting counsel is on court number 1. Let me be passed over for time being, my lord.
BTC, who appears? P Nayak. Okay, after some time.
Lordship.
44.
My lord, the petitioners in this case had completed their part. I am appearing for the NHPC. Now, my lord, to begin with, I'll just refresh my lord's memory because it has been a pretty long time. For one reason or the other, matter could not be heard earlier. My lord, the issue involved is promotion from the post of manager civil, which is E5, to that of senior manager civil, which is E6. The DPC did not find the petitioner suitable for promotion. It is that recommendation of the DPC which is under challenge on various grounds. Primarily, my lord, the 3 grounds were urged. I will deal with each of the grounds, but just certain basic facts so that, my lord, things are put in perspective. My lord, after I conclude my argument, I will also give a write-up subsequently, because if anything is left out or whatever they submit in their reply, my lord, I will make all the things clear in my written submission subsequently. Now, my lord, point to be noted is the petitioner had joined NHPC as junior engineer civil grade 2 on 19th of January 2004. So from 2004 to 2018, that is manager civil. He became manager civil on 1st of April 2018, which is E5. So from 19/1/2004 to 1st of April 2018, he got 5 promotions. This is I'm pointing out from the simple reason. It is not that there is some organizational bias against him as such. He kept on getting promotion on time. Till 2018, he got 5 promotions. On completion of 4 years of qualifying service in 2022, then he became eligible for promotion to the post of senior manager, and the DPC set, because the qualifying year of service is 4 years. He became manager civil on 1st of April 2018, completed 4 years of qualifying service on 1st of April 2022 for promotion to E6 from E5. The DPC, my lord, set immediately thereafter, considered his case for promotion, did not find him suitable. From there, the problem arose. So, my lord, it is not that there was some kind of an institutional bias. He kept on getting timely promotion. It is only at the stage of E5 to E6 that for various reasons, my lord, he was not found suitable. The only thing I'll have to demonstrate before my lord is that the decision of the DPC of not finding him suitable is perfect, just, fair and proper. There is no wrong in that. Now, my lord, before I come to certain other relevant aspects, some of the clauses of the promotion policy I should point out. My lord, for that purpose, instead of turning to the paper book, because this promotion policy also had undergone amendments. So, my lord, I'll just give the full version, including the amendments.
You have 4 respondents, 2 to 4.
Yes, my lord.
Yes.
To
This
begin,
is the amended promotion policy.
even the amendments are incorporated in this policy.
Okay.
So that's why, my lord, it will be much more convenient for your lordship, instead of looking separately into the amendments. To begin with, lordship may turn to clause 8. Clause 8 for promotion, clause 8. (8.1). Clause 8, lordship, there is a chart. First of all, let me show the chart. Clause 8, there is a chart. The qualifying period of promotion shall be as under. Lordship may look at E5, E1, E2, E3, E4, E5, E5 to E6. My lord will find for existing executives 4 years. So qualifying period is 4 years for existing executives. Engineering professional.
E5 to E6.
Yes, E5 to E6.
It's 5 years.
My lord, for existing executives, engineering professional qualified, graduates. Lordship will see 1, 2, 3, 4, fifth column.
Okay, engineering.
Yes,
graduate.
yes, yes. He's an engineering graduate.
Hmm.
There is no quarrel on that. 4 years. Now, my lord, 8.1. I'll leave 8.1 for a moment. Then, my lord, 10.1. The 10.1, my lord, is the constitution of DPC. The DPC is to be constituted once in a year, effective from 1st April. Lordship may see 10.2. The constitution of the DPC for the consideration of promotion for the grade of E8 to E9 shall be approved by the CMD. And this is important for us. And for the consideration of promotion from the for the grade up to E7 shall be approved by the director personnel. The DPC shall have one external independent expert. The composition of DPC shall be as per Annexure 4. Annexure 4, my lord, will get my lord, there is a schedule thereafter in the last portion, the last 2 pages, the second from the last, Annexure 4.
From the last page.
Second from the last, yes. E5 to E6, my lord will get, my lord will leave the last page and my lord will look at clause 4. Annexure 4, clause 4.
Yes.
For consideration of promotion from E5 to E6, the composition is given. I'm just showing all this, my lord, though, my lord, they in their pleading, they have also questioned the composition of DPC. But so far as my memory goes, Mr. Chaudhary did not argue on that point. Submission was not made on that, but pleading is there. So, my lord, if necessary, because I do not know, till now, my lord, they have not touched upon the composition of DPC part. In case if they do in the reply, then, my lord, certainly I will supplement. The next is 10.2. That I have already shown. Composition of DPC, 10.2. Then is 10.5. This has some relevance. Factors to be considered by DPC while awarding marks for interview. 10.5. The DPC shall interview executives in the grade of E1 and above and up to E5 with a view to ascertain their suitability. My lord, these words are loaded. With a view to ascertain their suitability. So the job of the DPC is to ascertain the suitability. So far as merit is concerned, there are parameters for merit. That's a mechanical exercise. DPC is to see the suitability. Interview is for that purpose. With a view to ascertain their suitability for the next higher position. Marks for interview shall be awarded by the DPC taking into consideration factors like. So the 2 words are there, factors like, which means, my lord, it's not exhaustive. Factors have been indicated, but not that it is only these factors. The factors like. So the factors like would make it, my lord, there is a degree of, one may construe this liberally. Something of that nature. Factors like. What are that? Educational qualifications, consistency in performance. On educational qualification, my lord, I may clarify. So far as merit part is concerned, for educational qualification, marks are awarded. But that goes into the merit component. So far as DPC is concerned, when education qualification is there, what is to be seen is educational qualification in the context of suitability. Whatever qualification you have, how that qualification you project while facing the interview board. One may have the degree. One may have the degree, but when you present yourself before the interview board, how that qualification gets reflected in your personality, in your interaction with the members of the interview board. This is what it is all about. Because marks for educational qualification are separate in the merit column. I will show that. Consistency in performance, professional knowledge, ability to reason out logically, presentation of ideas coherently, environmental awareness, leadership, potential for decision making, communication skills, sense of involvement, commitment to the organization, recognition, appreciation letter of director CMD, warning, caution letter issued by disciplinary authority, etc. Barring 2 or 3, my lord, barring the last 2, in most of the cases, it is the perception of the members of the board. When you sit before the members of the board, when you interact with them, when the questions are asked, how you come out, how you project yourself. Barring the last 2, there can be documentary evidence. Other aspects, my lord, it has to be reflected in your personality. Of course, the argument has been made that the marks scored in the PAR, performance appraisal report, ought to have been taken into consideration. That is not the case, my lord. That can't be, and I will show why this cannot be. PAR, they allot the marks separately. That is for the purpose of merit. Even the computer can do that exercise. Your gradings are provided, marks for the gradings are provided, you feed the data into computer, computer will tell you the result. Those marks are taken into consideration, but interview board is a different ball game altogether. Then, my lord, clause 4.7. 4.7.
Yes.
4.7, promotions up to E6 grade shall be based on eligibility and merit subject to suitability. So, my lord, 3 words, each of the word is important. Eligibility, merit, and suitability. Eligibility, 4 years of qualifying service. You are eligible. When you complete 4 years of qualifying service, merit, marked on education, marks for your professional qualification, marks on PAR, etc., etc. Those things are there, I will show. And then suitability by DPC. As a cohesive whole, all the things are taken into consideration. Suitability determined by DPC, marks are allotted for separate purposes for which merit is determined, and eligibility 4 years of qualifying service. The 3 taken together determine the scope of promotion. So, my lord, DPC was constituted in the month of February 2022 for the purpose of promotion from E5 to E6.
February 2000?
February 2022. And it was made clear that the DPC shall be effective from April. Naturally, because so far as the petition is concerned, he acquired 4 years of qualifying service on 1st of April 2022. So, DPC was with effect from April 2022. Naturally, to save time, they had done it, and there is nothing wrong with it. Because the rule says DPC has to be constituted every year. 10.1, again I'll show. Again, my lord, I'll point out. Though this has not been questioned again in their submission, but there are certain pleadings to the effect. The Departmental Promotion Committee shall be constituted only once in a year, effective from 1st April. So you may constitute DPC in the month of February. The question is, when will it sit? Effective from 1st April. The vacancy will be calculated after considering the following for determining the number of vacancies as on 1st April. So, my lord, they constituted DPC in February 22. All the vacancies up to 31st of March or 1st of April were considered, and DPC, my lord, considered the cases of all those very candidates who had acquired eligibility as on 1/4/2022. Petitioner, that is why he became qualified. Otherwise, had DPC said prior to April, he would not have been qualified. So, there can't be any grievance on that. The moment he acquires qualification, there is DPC present to consider his case. He is considered not found suitable. Now, my lord, on 4th of March, the next date is 4th of March. On 4th of March 2022, circular was issued calling for eligible candidates for interview. There are total 24 candidates called for interview. And in terms of clause 11.1, only 50% could be promoted. Well, that's the requirement of the rule. I'll show 11.1. The total number you will call, all those who are qualified, out of them 50% will get promoted. That is the bar. In terms of merit, 11.1. My lord will see the chart in the 11.1. E5 to E6, 50%. So 24 called. Out of that, 12 will be taken in terms of merit. In terms of merit. On 9th of March 2022, petitioner submits a representation for giving him marks for PG diploma in energy management. This is one ground, my lord, they have taken. This was argued also. Since, my lord, he had acquired higher qualification in course of service, so he was entitled to be given marks and he submitted a representation for that purpose on 9th of March 2022. This was important because DPC was there in the month of April to consider this case for promotion. Now, my lord, in this context, clause 8.1 is relevant. 8.1. Let me kindly be seen. In order to encourage employees to acquire higher educational qualifications leading to improved performance, maximum up to 5 marks shall be awarded for promotion from E2 to E3 and above on the following manner. 1 mark each for additional degree diploma. Meaning thereby, my lord, if you have 1 diploma, you get 1 mark. If you have another diploma in another discipline, another mark. Second category, paper, publication and Scopus indexed journal. Or if you publish a paper, you get, or for each publication, you will get 1 mark. But it will not go beyond 5 marks. So, my lord, what he had acquired additional qualification, that is PG diploma in energy management. So, he was entitled to 1 mark. Now, my lord, at the outset, I will admit, it is true that this additional 1 mark was not given to him. Of course, my lord, NHPC has given its own reasons. The reasons may be right, the reasons may be wrong. My submission would be, even if this 1 mark would have been awarded to the petitioner, it would have made no difference because total marks he got was 72. 72 would have become 73. Reason for his unsuitability was he failed to get the qualifying marks in the interview. The qualifying marks in the interview were not 8. He got 6. This mark, 1 mark, was to be given to him for additional qualification in terms of, that is, my lord, that is 8.1. Clause 8.1. And I will show the column. It is for additional qualification that goes into the merit component. Merit is determined on the basis of that. So, my lord, he was already qualified. Merit is very high. Total mark 72 he would have got 73. Assuming had he got this 1 mark extra. But fact is, in interview he got 6 marks. 6 could not have become 7 for that. Because interview was on the basis of other parameters. His personality, the way he's performing before the interview board, what he's reflecting in his interaction with before the members of the interview board, etc., etc. I will deal with that aspect next. So this is one area. You know, I will deal with it elaborately at a later stage. So on 10th of March 2022, petitioner along with 23 others appeared. So far as petitioner is concerned, my lord, he appeared for interview through VC. On 29th March 2022, 12 out of 24 executives were promoted from the
Well-
cadre of manager civil.
What does the date, 25?
My lord, on 29th March 2022, that is 2022, 12 out of 24 executives were promoted from the cadre of manager civil, E5 to senior manager.
12 out of
24. Naturally, my lord, because it is 50%. Lordship has seen clause 11.1. 24 were called, only 50 could be promoted. Petitioner did not figure among those 50%.
E6.
Yes, E5 to E6. Petitioner's name did not figure among the 12 who were found suitable. And I'm already making it clear, his name did not figure among the 12 successful candidates for promotion because he was not found suitable by the DPC. This is because out of minimum qualifying marks of 8, petitioner could secure only 6 marks. Now, my lord, I will just show the division of marks also, the relevant clauses. I have already shown your lordship 8.1, 8.1 for the purpose of additional qualification. That is 5 marks. 1 mark each for each additional qualification. Then, my lord, there is performance appraisal report. That, my lord, will get clause 9.5. There are total 5 performance appraisal reports from 1st of April of a given year to 31st of March, which is to be considered. Clause 9.5 may kindly be seen first.
Yes.
Except in case of fresh appointments, the DPC shall consider appraisal reports for a period of 5 years, immediately preceding the year of assessment, including the last appraisal report. In case of fresh appointments where 5 appraisal reports may not be available, the DPC shall take into consideration all appraisal reports for the period of eligibility. An average of 4 reports shall be taken as the rating for the 5th year. We are not concerned with this part because 5 PARs were available. Total 4 and another PAR of the earlier year was taken into consideration. So he has no grievance on that. 5 parts were taken into consideration. Now appraisal system in par is, my lord, 9.6. 9.6. The appraisal system will be on a 5-point scale: outstanding, very good, good, average, and poor, as defined in the appraisal formats. Then, my lord, 11.3. 11.3. How the marks are given. Performance appraisal report, 60 marks. Total 60 marks are to the performance appraisal reports. Performance appraisal report shall constitute 60 marks in all. The appraisal system will be on a 5-point scale: outstanding, very good, good, average, and poor. Each of these ratings have been defined in the formats of appraisal reports. For the purpose of aggregation, marks shall be allotted to various ratings as under. Outstanding gets 12. So below 12 multiplied by 5, 5 years. 12 multiplied by 5 makes it 60. Total marks 60. Outstanding 12, very good 10, good 8, average 6, poor 0. Then, my lord, 11.4 deals with, my lord, the minimum marks. This I read: an executive whose performance appraisal report in any of the last 3 years is poor, immediately preceding the year of consideration, shall not be considered for promotion by the DPC. Adverse entries in the part shall also be taken into consideration by the DPC. The minimum qualifying marks for promotion in part shall be 44 marks. So the minimum qualifying marks are 44 out of 60. My lord, here there is no difficulty because the petitioner acquired much more than 44. So, my lord, he has no grievance on that score. In par, he performed very well. His marks are fairly high. I will show the mark sheet. So, my lord, this part I skipped. Because he got much more than qualifying marks, much more than 44. Then, my lord, interview. Interview 11.5. That is E5 to E6. The various categories are given here. E5 to E6 is mentioned. The DPC will award up to a maximum of 15 marks to each eligible executive for interview in terms of subpara 10.5 above. 10.5 above means factors. Factors like. The word like was used there. Subpara 10.5 above. Keeping in view the relevant factors defined therein. That is it. So total marks 15. Now, my lord, 11.8 may also kindly be seen. Minimum qualifying marks. 11.8. That is minimum qualifying marks in the interview. Minimum qualifying marks have been reflected at Annexure 3. The minimum qualifying marks in interview. Annexure 3 may kindly be seen. This is the total chart. My lord will see the last two columns in the chart. Last two columns, it deals with the par and the interview both. Lordship will see the last but one column. That is second from the last. Par 44. It is for general category because my lord, petition is general, not SC or ST. Interview 8. I have marked 8. 8 is the minimum qualifying mark for interview out of total 50. And my lord, various categories are given here. Lordship will see the second column itself, the marks for par 60. Since there is no written test, so my lord, that is blank. Then seniority, 10 marks. So far as seniority is concerned, my lord, petitioner did not get any mark. For the simple reason, he acquired qualifying years of service of 4 years on 1st of April 2022. Immediately he was considered. So, my lord, it was just at the right time. So, there was no question of marks in the seniority. But I will show, my lord, how the seniority marks are calculated. Then DPC marks for interview. Interview 15. Minimum lordship has seen 18. Field exposure 10 marks. On field exposure, I will make my submission because argument was made by the petitioner that field exposure is essential. Petitioner is right. It is essential for the purpose of promotion. So petitioner has alleged that there were candidates who did not have requisite field exposure for the purpose of promotion, but in spite of that, they were promoted. I will answer that question. The allegation which is made is correct, but how far that allegation is contrary to law, that is, my lord, we have to examine. And I will demonstrate before a lordship, the rules were followed. There was no special bias for anyone. That part I will deal with. Then, qualification marks 5. Qualification marks 5, that is below that I have shown, 8.1 already. 5 marks maximum. He could have got 1 mark here extra. Out of 5, he could have got 1 because of PG and diploma, which was not given to him. But had he got it, my submission is, out of his total marks are 72, he would have got 73. But in interview, he got 6 marks, which is less than minimum 8. So he is found unsuitable because of that. For a moment, my lord, I'll just, for lordship's benefit, lordship may like to have a look at it. My lord may look at the mark sheet. I brought the original record. To have it? Yeah. It's all stamped and sealed. My lord, in fact, on the last occasion, the officials had come with all the original records, but it was agreed between us that even the officially verified documents will do. So, my lord, the documents where this official seal is there. Now, lordship will see the flag marked one. The one which is flag marked.
Yes.
The name of petitioner is at serial number 11.
Yes.
Serial number 11, that page is flag marked. Lordship will see the total marks towards the right hand side. Not recommended is written there, 72. Now, how do we get the total mark? My lord, the breakup is given. In interview, my lord, he gets 6. Minimum qualifying is 8 out of total 15. He gets 6. Then my lord will find locational weightage, maximum marks 10, that is field exposure. My lord, in field exposure, petitioner gets the maximum mark. 10 out of 10. He got 10 total. Maximum marks 10. Petitioner had the requisite field exposure. He could have got total 10 marks. He was given the full mark, 10. Then my lord will find that is par, marks for the par. Maximum marks 60. The very next column. I'm moving towards the left from right. Out of 60 my lord in par, total 5 par, he got 56. Very high marks in par also. So my lord, 56 plus 10, 66. 66 plus 6, that is marks for the interview, 72. And had he got that 1 mark for PG in diploma, 73. But the question is, what do you do with 6 marks in interview? Out of total 50. Minimum qualifying marks be 8. Therein lies the whole problem. And I will have to show that marks were fairly awarded, so far as interview is concerned. He was found not suitable because of this. And in fact, my lord, the highest marks scored by anybody, the highest marks here I find is 74. 79. 79. Though, my lord, I have not really calculated, but highest marks are 79.22 recommended. 79. Possibly in terms of merit, petitioner will be yes, my lord. Out of total, my lord, I find that petitioner will be somewhere in terms of merit at number 6. Total 72. If we make a chart in serial order, because maximum, the highest is 79.22. He's 72, somewhere at number 6. So in terms of merit, he's making it. Hands down, he's making it. But for the interview. But for the interview. Even without the 1 mark, which could have been awarded to him, he was making it. But for the interview, where he got 6. Now, lordship, I will just show the marks for the seniority.
For the interview, the qualifying mark is 8.
8. Minimum qualifying.
Where is that specified?
It is just now I showed to you, lordship. Just now. Again, I'll show.
In that policy?
Yes, in the policy itself. Again, I will show. Again, I will show.
Or that annexure 3?
Yes.
Correct?
Yes.
Yes. Yes.
Annexure 3. First, lordship will see 11.8.
I've got it.
And lordship 11.8. Subpara 11.8, read with annexure 3. 2 things have to be read in conjunction. 11.8 says minimum qualifying marks have been reflected at annexure 3. And annexure 3 shows 8 minimum qualifying marks.
Yes.
Though my lord, petitioner has not advanced any arguments on seniority aspect, that has not been questioned. That as to why he was given 0. But I am just clarifying it. Petitioner is satisfied with the marks given to him because seniority could not have got any mark. 11.6 may kindly be seen. How marks are given for seniority? 11.6. Weightage for seniority, total 10 marks. The DPC shall award a total of 10 marks for seniority in the grade. 2 marks shall be given for each completed year beyond the eligibility period. Beyond the eligibility. That is, the year you are eligible, if you are not promoted, you cross that period, then 2 marks for each year, each completed year. In his case, my lord, April 2022, we attained the qualifying years of service of 4 years, and my lord, immediately he was considered. So there was no question of petitioner being awarded marks for seniority. And in any case, petitioner has not made any grievance on that. He is satisfied. He was not entitled to any mark on the count of seniority. Then, my lord, locational weightage, 11.7. That is field exposure. That would be a relevant subject. I will have to address on this aspect because serious allegations have been made. 11.7. reads, the DPC shall award a total of 10 marks for field exposure as under E5 to E6. That is cumulative service in executive grade at project and power station. Field exposure means service at the project and power station. So less than 2 years, you will not get any mark. If you spend less than 2 years in project and power station, you will not get any mark. 2 years to less than 7 years, you get 3 marks. 7 years to 9 years, you get 6 marks. And more than 9 years, you get 10 marks. Now, my lord, point to be noted is, so far as the petition is concerned, he got full marks, 10 out of 10. Because his field exposure, my lord, is more than 9 years, and he was given full marks, 10 out of 10. So there is no grievance on that count. The grievance is others who did not have requisite field exposure were given the promotion in violation of the policy. This is one of the allegations. So far as distribution of marks in the promotion policy is concerned, I have already shown, my lord, in Annexure 3. I need not. Now, my lord, straight away, before, my lord, I come to the first argument, I'll just, my lord, composition for DPC. Let me just make it very clear. It was 6-member DPC in the present case. 6-member DPC. For a moment, my lord, will see Annexure 4.
Yes.
That is GGM within bracket HR stroke GMHR. The GMHR was present. GMHR was present. He, my lord, he belongs to SC category. So there was representation from scheduled caste also in the composition. The DPC consisting of following members shall be constituted by the director personnel. Director personnel had constituted the DPC. The GMHR was present and he was from SC category. I will give the names also later on. No, names are there, in fact. Once I will give. The names are here. I will hand over to my lord the proceedings of the DPC. Lordship may see this. Give him. It's for him. Because it is consolidated. Consolidated. My lord, the flag marked one, lordship will see the recommendation of DPC. E5 to E6. All the 12 names are given. This is the only relevant portion. All the 6 marks are given. Or like 6 member signatures are there. 12 names have been shown.
Where's the petitioner?
Milord, petitioner did not figure his name because he was found unsuitable by DPC. Only 12 out of 24 were promoted. Since he was found unsuitable by DPC because of having secured less than qualifying marks for interview, qualifying marks being 8 out of 15, he got 6. So he was unsuitable. But Lordship will see the total marks. The highest is 79.22. Next is 79, 78.5, 74.4, 73. There is one Archana Kumari Shah who scored 72 like the petitioner. Had petitioner got below requisite marks in the interview, had he got the qualifying marks of 8 minimum, my lord, he would have figured possibly somewhere at 5 or 6. Somewhere at 5 or 6. Because there is no difficulty about the merit. Merit is there. He got very good marks in power, very good total marks for field exposure, etc. Issue is there, 1 mark for PG diploma, not given to him, rightly or wrongly. Had he got that mark, it would have made no difference. From 72, he would have gone to 73. But the marks in the interview, my lord, could not have been compensated. He didn't get the requisite marks. He got only 6. So, my lord, the composition, I'm just making it clear. The general manager HR was present. It was constituted by director personnel. GM HR was present, and he belongs to SC category. One Mr. R.T. Nathan. Then GM of technical discipline. He was Anand Kumar, electrical. All their signatures are there. Then GM of non-technical discipline. He was also present. And external independent expert. The external independent expert was one Mr. N.V. Kumar from National Power Technical Institute, from a different organization. Then Lordship will see the note. In case there is no SC, ST, OBC, minority or women member in the DPC, additional members belonging to these categories shall be co-opted, not lower than E7 level. So, my lord, so far as SC was already there was already SC representation in the form of, my lord, GMHR, because GMHR belonged to SC category. So far as from women, my lord, representation was taken. The GM law, my lord, is an officer belonging to E7 level or above. So the GM law was also co-opted as a member of the DPC because she is a lady. So it was a pact below DPC with independent expert, all senior officials. Apparently, my lord, on prima facie, one can't say that they will nurture any bias. And bias, why all of a sudden? Because from 2004, continuously you were getting promotion one after another. You got 5 promotions. Now, my lord, I will come to the allegations, one by one. Now, my lord, the first argument, if I remember correctly, the first argument advanced is the interview board, because their entire focus is on the interview board as to how come I got 6 marks. Had I been given 8 marks, I would have easily qualified. I would have been promoted because I was already higher up on the merit. So the argument is interview board arbitrarily awarded marks. There was total and complete lack of objectivity. It was also argued that the marks were not awarded under different heads because 10.5 provides various categories. So the argument was marks got to be awarded for different heads.
Yes.
It was also argued that all those who did not qualify in the interview, well, all those who were not found suitable by the DPC, they got similar marks. Meaning thereby, those who don't qualify, they all were given 6 marks, 6 marks, 6 marks, if you don't qualify. And lastly, my lord, it was also argued in the context of interview that DPC did not record any reason. What for you are giving 6, what for you are giving 8, what for you are giving 9, no reasons were recorded. Now, my lord, my submissions are as under. Firstly, my lord, I will now refer to 10.5 again, the clause. The object and purpose of interview board, that is DPC, is to ascertain the suitability. By taking into consideration, quote unquote, factors like, I'm also giving emphasis to the word like, factors like. The factors like would indicate not exactly that factor, something more than that, similar to that. So, you know, that's very broadly, in a very broad spectrum, we are looking at it. The factors, cohesive factors taken together, these are the things. Purpose to ascertain the suitability. And my lord, in terms of clause 4.7, the promotion has to be based on eligibility, merit, and subject to suitability. The three components are there. Eligibility, 4.7, 3 words. Eligibility, that is 4 years of qualifying service. Merit, 60 marks for par, marks for additional qualification, marks for field exposure. All that makes it merit. Subject to suitability. There comes interview. That is 15 marks. Are you suitable? I may be not higher upon merit. Certainly, I would be eligible if I am considered. Eligibility, I go through. Merit, I score high marks. Suitability, am I suitable? That would be the question I would be asking myself. And whether on correct parameters, I was found unsuitable. And whether, my lord, to what extent the Honorable Court would enter into this very kind of an inquiry, the scope of judicial review. Because finally, my lord would try to ascertain as to whether DPC acted rightly in awarding certain marks for the interview. So the scope of judicial review in that area. Now, my lord, there are 3 to 4 paragraphs in our counter affidavit wherein we have dealt with this very aspect of allotting marks in the interview. Those paragraphs I will point out. Lordship may turn to paragraph 19 of our counter affidavit. In response to their arrest petition. Para 19 at page 237. I will just point out the paragraph, then, my lord, I will advance my arguments, touching upon the legal principles. 237 of the paper book. Whether my lord has got it? Yes. Further, the petitioner has also alleged, albeit incorrectly, that the DPC did not follow the 12 criteria mentioned in clause 10.5 of the departmental promotion policy. In this regard, it is stated that each and every interview conducted by the DPC and each and every question asked by the DPC is done keeping in mind the 12 criteria mentioned in clause 10.5. Then, my lord, page 254. Page 254. Again, para 19. Now, here, my lord, the relevant portion would be, instead of reading everything, let me read para 19. The relevant portion is slightly, my lord, on the lower side, but, my lord, other lines also may be relevant for your lordship.
1 minute, this para 19 is what?
My lord, actually, the thing is, my lord, it is like, my lord, in the counter affidavit, first is preliminary submissions, followed by para-wise replies.
Okay.
So that is why para 19 is figured twice. Para 19, that is why, my lord, I am also pointing out the page number. There is one para 19 in the preliminary submission, and there is another para 19, my lord, in giving para-wise replies. That is how they have numbered.
Yes.
My lord, 11th line from the bottom at page 254. 11th line. from the bottom. The line begins with, my lord, it starts from the middle, it is denied. 11th line from the bottom. Whether my lord has got it. It is denied. It is denied that the marks awarded to the petitioner during the interview process were given without adopting any rational criteria while awarding the marks for the viva voce. It is denied that the marks were required to be bifurcated under 12 heads stroke factors. It is denied that every member of the interviewing committee was supposed to record their marks individually in their own sheet, because this was one of the arguments. The pleading case, what they had pleaded was that each member ought to have given the marks separately. It is denied that every member of the interviewing committee was supposed to record their marks individually in their own sheet against each head stroke factor, and total from all the members were to be averaged to reach the final awarded marks in the interview. It is denied that lump sum marks have been awarded by the committee to ensure the rejection of the petitioner. It is reiterated that the marks were awarded in the interview after deliberations and unanimous consent of all members of the interview committee. So, my lord, the procedure they adopted was all the members, my lord, questions will be put. Thereafter, all the members will discuss among themselves. And, my lord, there would be a unanimous decision. This should be the mark instead of acting separately. Because there is no requirement in the rule of the lordship has seen that. So, as a cohesive unit, the interview board acted. After discussion, they awarded marks. Then, my lord, at page 244 of the same counter, paragraph 13, page 244. It is stated that as per the departmental promotion policy, the qualifying marks in interview for general category is 8, but the petitioner was awarded 6 marks by the DPC. In view thereof, the petitioner was not recommended for promotion for the next higher grade, that is E6. With regard to the allegation made by the petitioner that the marks of the 7-member DPC were jointly awarded, it is stated 6-member DPC, not 7, my lord. It is stated that the marks were awarded after deliberations and unanimous consent of the entire 7-member DPC. My lord, total I find in fact is 6 in my, I don't know, 7, 1, 2, 3, 4. Then is another 5. Sorry, 5 and 6. Yes, total 6. Total 6. The chairman was from minority community. It's not 7, it's total 6. Total 6. So, my lord, these are the pleadings in our counter affidavit connected with the interview. Now I'll come to the legal principles. Firstly, my lord, the reasons ought to have been given as to why you have given lesser marks. Why have you given 6? What are the reasons? No reasons recorded. So this, my lord, my argument is that the selection committee is not required to give reasons. The 2 judgments I am citing, 1992, list of books, 1992, Supply 2 SEC, page 481. That is National Institute of Mental Health and Neurosciences versus K. Kalyanaraman. 1992, Supply 2 SEC 481. The relevant para is below paragraph 7. And also para 8. The 2 paragraphs will be relevant, 7 and 8. I read para 7 first. At page 484.
Yes.
We will first consider the second point. In the first place, it must be noted that the function of the selection committee is neither judicial nor adjudicatory. It is purely administrative. The High Court seems to be in error in stating that the selection committee ought to have given some reasons for preferring Dr. Gauri Devi as against the other candidate. The selection has been made by the assessment of relative merits of rival candidates determined in the course of the interview of candidates possessing the required eligibility. There is no rule or regulation brought to our notice requiring the selection committee to record reasons. In the absence of any such legal requirement, the selection made without recording reasons cannot be found fault with. Then, my lord, the last line at placitum I in the same para 7 at page 484. That is administrative authority. Administrative authority, because, my lord, according to Supreme Court, the selection committee acts in administrative capacity. It is not adjudicatory or judicial body. Administrative authority is under no legal obligation to record reasons in support of its decisions. Indeed, even the principles of natural justice do not require an administrative authority or a selection committee or an examiner to record reasons for the selection or non-selection of a person in the absence of a statutory requirement. Here, my lord, the rules are silent. There is no statutory requirement that reasons you have to give. This principle has been stated by this court in R.S. Das versus Union of India, in which Kapoor's case was also distinguished. As to the first point, then para 8, my lord, as to the first point, we may state at the outset that giving of reasons for decision is different from, and in principle distinct from, the requirements of procedural fairness. The procedural fairness is the main requirement in the administrative action. The fairness of fair procedure in the administrative action ought to be observed. The selection committee cannot be an exception to this principle. It must take a decision reasonably without being guided by extraneous or irrelevant consideration. But there is nothing on record to suggest that the selection committee did anything to the contrary. So, my lord, here my submission is also precisely that. Selection committee did not deviate from the rule. It took into consideration all the factors. It was not required to give reasons, and it did not record any reasons correctly. The members discussed among themselves. They were not satisfied with the performance of the petitioner, and accordingly, my lord, they judged him unsuitable for the promotion. Then, my lord, the last line at page 485. The last two lines, page 485. It should not be lost sight of that the selection committee consisted of experts in the subject for selection. They were men of high status and also of unquestionable impartiality. The court should be slow to interfere with their opinion. My lord, one was independent expert from a different organization. All are very senior officers of the NHPC. 6 of them sitting together arrived at the unanimous conclusion that, look, he doesn't deserve more than 6. He doesn't qualify for the promotion. That is how it is. The same principle was reiterated in 2020, 16 SEC, page 799. That is Baidyanath Yadav versus Aditya Narayan Roy. 2020, 16 SEC 799. The relevant paras are para 8.2 and para 8.3. I read para 8.2. At page 808.
Yes.
Moreover, we find ourselves in disagreement with the conclusion of the High Court that the decision of the State Screening Committee was arbitrary for non-disclosure of reasons. A catena of the decisions of this court has established that even the principles of natural justice do not require a duly constituted selection committee to disclose the reasons for its decision, as long as no rule or regulation obliges it to do so. In this regard, we may refer to the decision of this court in National Institute of Mental Health, which I had already cited prior to this, the same principle they reiterated, which has also been subsequently affirmed in several cases, including UPSC versus Arun Kumar Sharma, National Institute of Mental Health, such as such. The court following the decision in R.S. Das versus Union of India observed as follows, without the same proposition they have referred to, quoting from R.S. Das. Then 8.3, the court says, as there is no such requirement mandating the disclosure of reasons in the relevant rules, regulations, and guidelines, there is no doubt in our minds that the procedure adopted by the State Screening Committee cannot be faulted. That's it. Then, my lord, the second line of argument in connection with the interview itself, that there were so various parameters, various criteria. Now, the marks ought to have been given for the separate criteria. Each criteria, separate marks ought to have been allotted. That would have been better and fair. So this, my lord, the principles are, I'll refer to two Supreme Court judgments, that is 1995 3 SEC, page 486. The principle is, if rules are silent, it is not required to give separate marks for various parameters. 1995 3 SEC, page 486. That is Madan Lal versus State of Jammu and Kashmir. The relevant paras are para 13 and para 14. 1995 3 SEC 486, paragraph 13 and paragraph 14. Para 13 I read, my lord. My lord, better I begin with 12, para 12, to understand the context.
Yes.
Para 12 starts at page 493. So far as the first contention is concerned, London Senior Counsel for Petitioner submitted that Rule 10 of the rules lays down that the examination for selection of candidates shall consist of written examination as well as viva voce test. So far as written examination is concerned, it is not challenged before us as noted earlier. So far as viva voce test is concerned, Rule 10(1)(b) lays down as under. The object of viva voce examination is to assess the candidate's intelligence, general knowledge, personality, aptitude, and suitability. So, my lord, the words used were intelligence, general knowledge, personality, aptitude, and suitability. The argument was separate marks ought to have been there for each of the parameter. Marks for intelligence, marks for general knowledge, marks for personality, aptitude, and suitability. The London Senior Counsel for Petitioner submitted that when a candidate is orally interviewed, this is very vital, my lord. The London Senior Counsel for Petitioner submitted that when a candidate is orally interviewed, the members of the committee should assign separate marks for the different faculties of the candidate concerned, namely intelligence, general knowledge, etc., as laid down in the rule, and that does not appear to have been done by the interviewing committee. And hence, the entire viva voce test is vitiated. In this connection, reliance was placed on the decision of this court in minor A, Periyakkarupam versus State of Tamil Nadu. So, my lord, that judgment was also referred for this principle. Now, my lord, the answer is given by the court. Para 13. It is not possible to agree with this contention. So far as Rule 10(1)(b) is concerned, it does not provide for any separate assessment of marks for candidates at viva voce examination faculty-wise. That is, on intelligence, general knowledge, etc., listed in the said rule. On the contrary, it appears that as per the said rule, while conducting viva voce examination, the committee has to keep in view the main object of assessing such candidates in the light of the guidelines given therein. Without pausing here, I submit. In our case, it is finally to adjudge the suitability by keeping in mind those factors. In other words, the interviewing committee has to keep in view the overall performance of the candidates at the oral interview, overall performance at the oral interview. And while doing so, their intelligence, general knowledge, personality, aptitude, and suitability have to be kept in the center. The rule merely lays down the object of assessing such candidates in the viva voce examination. It is a general guideline given to the interviewing committee members. Therefore, it is not possible to agree with the submission of the Senior Counsel for Petitioners that the members of the interview committee must separately assess and give marks on different listed topics faculty-wise as per the said rule. So far as the decision of this court in minor A Periyakkarupam versus State of Tamil Nadu is concerned, it has to be kept in view that this court was dealing with admissions to MBBS course in the State of Tamil Nadu. The selection committee was constituted for assessing the merits of the applicants concerned for such admissions at oral interview after written test. 75 marks were assigned for oral interview. The selection committee was asked to award these marks on the basis of following 5 tests. 1. sports of National Cadet Corps activities, 2 extracurricular special services, 3 general physical condition and endurance, 4 general ability, and 5 aptitude. Now it becomes at once clear that when 75 marks were to be assigned to a candidate called for oral interview on the basis of the aforesaid 5 types of performances by the candidate, the assessment of first 3 tests would depend upon the documentary evidence regarding his career record, which the candidates can furnish to the interview committee, while the last 2 tests will depend upon his performance at the interview. In view of this hybrid type of test for which assessment was to be made at the oral interview, 75 marks assigned for all these 5 tests necessarily had to be split up, and from the career record of the candidate, separate marks had to be assigned for first 3 tests, and that necessarily required separate assessment of marks on the remaining 2 heads of test. It is in the light of this requirement of peculiar type of marking at the oral interview that it has been observed in para 16 and 17 of the report that it was clearly illegal to give marks in a lump sum, and that the committee had not divided the marks under various heads nor on item-wise basis. It is also to be kept in view that while selecting a student for admission in MBBS course, what is more important is his performance in the written test, and even at the oral interview, his past record of performance has its own weight. A student, while undertaking study, is not required to perform any duty, and this is important, my lord. This is very important. A student, while undertaking study, is not required to perform any duty of a public office. But in the case of recruitment to the post of Munsif, he is required to work at the grassroots level of state judiciary. This was the case of Munsif, my lord, that is Madan Lal was the state of Jammu and Kashmir. For candidates aspiring to be appointed in such a judicial office, apart from the written test, his overall performance at the oral interview is more important, and consequently, the split up of marks under various subheads at oral interview of such a candidate may not be strictly necessary unless the concerned rule regulating such a Viva test expressly provides to that effect. As we have seen earlier, Rule 10(1)(b) does not so prescribe, and hence it was open to the members of the committee to make an overall assessment of the interviewed candidates, keeping in view the various factors for such assessment as laid down by the said rule. That is precisely what has been done in the present case, as stated by such and such, a member of the interview committee in para 3 of your affidavit in reply. It is stated by her that only consideration which the members of the interview board had during the Viva test were to judge the candidates on the basis of their intelligence, general knowledge, personality, aptitude, and suitability, as required by Rule 10(1)(b) of the recruitment rules. That all the questions directed at the candidates in the Viva test were with this object in view, and the assessment had been made of the candidates at the Viva test accordingly. So, my lord, this is the principle. Now, my lord, the second judgment on this point, and that is more relevant for our case, that is 2000, volume 7 SCC, page 719. This principle, my lord, was explained in great detail. 2000, volume 7 SCC, page 719. The relevant paragraph is paragraph 29, 30, 31, and 32. (29, 30, 31, and 32). At 29, my lord will find the various factors to be considered by the interview board.
Yes.
Here, total marks were 75 for interview, and the factors to be borne in mind were: number 1, personality; number 2, knowledge of the subject; number 3, knowledge of current ideas and problems of the educational work, diagnostic attitude towards them; 4, general knowledge; 5, administrative ability regarding school management; 6, self-expressive and impressive views; 7, achievement in curricular activities of the regional and state level. Now, my lord, this was here the interview board was for the purpose of making appointments. Then para 30 comes. It is true that maximum marks for each item were not allocated. A perusal of the original list of participants in the interviews for the post of principals stroke headmasters with reference to each institution stroke school shows that the members of the commission who interviewed the candidates awarded marks in lump but separately after evaluating the candidate on the basis of aforementioned factors. On a careful consideration of the factors contained in the above quoted guidelines, we find considerable force in the submission of Mr. Santibhushan that overall evaluation, rather than awarding of marks for each item, will lead to proper and correct result, assuming that each of the factors in the guidelines is allocated equal marks in a given case. If the personality of the candidate and his administrative ability regarding school management are miserably poor, but his knowledge of current ideas and problems of educational work, general knowledge, and achievement in curricular activities, etc. are good, and he secures higher marks than a candidate who is having good personality, possesses imaginative administrative ability regarding the school management, and satisfies the other factors, certainly the former candidate will not be better than the latter as the principal stroke headmaster for an institution and the school. Pausing here, my lord, what the court is saying is, you may have a brilliant general knowledge, you may be very thorough with the current ideas, but you do not have the administrative ability. The way you are interacting with the members, it is evident you have no personality. Whether you will be better or the other person who is having brilliant, brilliant administrative ability, interacting, very, very articulate, etc. will be better. You may be very good in GK, may be very good in extracurricular activities, but extremely bad in interacting, not articulate, personality is not there. You are not interacting properly. That means you do not have the administrative ability. So therefore, my lord, the person with administrative ability, the person having other qualities, human qualities, may be more relevant for a given job than the one having very, very good GK. So that is why the court said, if one gets very, very high marks in GK, will make it. So that is why it will be very dangerous. As a whole, you judge it, then you form an opinion whether person will be suitable. That is why, my lord, the word used is suitable. Suitability is to be just for the particular post. It's a high post. What you require is the managerial ability. Managerial ability means you will have to interact with the human beings. You have to do the man management. We have seen many individuals, they may be otherwise very brilliant. We have seen many people, they may be very brilliant, but they make a very bad manager. Their behavior with the subordinate may not be good. They may not be very good at man management. Such a person are of no use. They may get very high marks. They may have very good field experience. They may write papers. They might even author a book. But it is totally different than running an administration. Whether you require that, whether you have that ability of running the administration, that is the question. And this is what the court answered. Then I read, such examples can be multiplied by permutations and combination. In our view, items mentioned in the guidelines are various aspects which have to be kept in mind in evaluating a candidate for his suitability and fitness for being appointed as the principal stroke headmaster of an institution stroke school. We therefore do not find any illegality in the procedure of overall evaluation of the candidate without fixing marks for each of the items noted above, adopted by the commission. And on this ground, we are not inclined to hold that the selection is arbitrary. Here we may, with advantage, mention a decision of this court in Dr. Keshav Ram Pal versus UP Higher Education Services Commission, Allahabad. In that case also, selection for the post of principal was under consideration. The appellant who claimed to possess higher academic qualifications and the longest experience was not selected. He challenged the selection on the ground that although the basis of selection was the candidate's academic attainments, teaching experience, administrative experience, and suitability for the post of principal, marks were not separately allocated under each of those heads. Therefore, the procedure was arbitrary and resulted in arbitrary selection. This court held that the interview board was not obliged to subdivide the marks and selection could not be said to be arbitrary in the absence of such subdivision. So, my lord, I rest my case there. It seems my lord may rise for a while. Very well. There were total 12 factors given, factors like 12 factors were mentioned. Out of 12 factors, my lord, the 8 factors, one has to ascertain only in course of the interview. There is no other methodology. For example, my lord will see at 10.5, at number 4, ability to reason out logically. Number 4, ability to reason out logically. Presentation of ideas coherently. Environmental awareness. Leadership. Potential for decision making. Communication skills. Sense of involvement. Commitment to the organization. Now, my lord, these are the factors. You ask questions, person react. You look at the demeanor, you look at the body language, you look at the manner in which the person concerned respond. On the basis of that, you will assess the human qualities. There is no other way. No, my lord, educational qualification, I pointed out earlier already. There is a separate mark allotted for educational qualification. That can't be lifted from there and included in the interview. You ask questions. You try to ascertain that in course of his service, what kind of practical knowledge he has acquired, connected with the education. So there one may not be satisfied. That is the answer. Consistency in performance. No, consistency in performance may not means your performance in the organization. Bar, yes, you have been given high marks, but that by itself may not be enough. We judge a person by various other factors. Professional knowledge, another aspect. Last 2 categories, my lord, recognition, appreciation letter of director, CMD for commendable performance. There can be documentary evidence. One may have it, one may not have it. I don't think he's having it. Even if you have the commendation letter of a CMD or of a director, that by itself will not ensure that you are promoted. Then warning and caution letter also, there can be documentary evidence. So barring the last 2 factors, my lord, there can't be documentary evidence of those factors. So those factors have to be assessed by the members of the board by asking questions. It can be very subjective. So we have to trust them somewhere that they are doing their duty diligently and properly. We can't proceed on a basis that they are biased against me merely because they don't give me adequate marks in the interview. So, my lord, on this, my lord, I come to a principle that there is always a presumption that selection committee has acted fairly. There is a presumption, my lord, in favor of holding that selection committee has acted fairly. Unless, my lord, there is unequivocal evidence to the contrary. The principle, my lord, is that is 2006, 8th SCC, page 192. Presumption that selection committee has acted fairly. Union of India versus Vikas Kumar. Para 13, my lord, I will read first. The respondent at para 13 at page 195.
Yes.
The respondent was recruited not only on the basis of marks obtained by him in the matriculation examination, but also upon consideration of various other criteria necessary therefore. He filed all necessary and requisite documents. The candidature of all the candidates has been considered on their own merits. Only because one Pitambar Machi had obtained higher marks in the matriculation examination, the same by itself should not have been a ground for cancelling the order of recruitment passed in favor of respondent. Then comes the vital portion, my lord, at para 14. When a selection committee recommends a selection of a person, the same cannot be presumed to have been done in a mechanical manner in absence of any allegation of favoritism or bias. A presumption arises in regard to the correctness of the official act. The party who makes any allegation of bias or favoritism is required to prove the same. In the instant case, no such allegation was made. The selection process was not found to be vitiated. No illegality was brought to our notice. In this view of the matter, we are of the opinion that the said Pitambar Maji, by reason of higher marks obtained by him in the matriculation examination, also cannot be said to be a better candidate than the respondent herein. In this view of the matter, we do not find any fault with the impugned judgment of the High Court. So, my lord, pausing here, I submit, in this case also, my lord, there is no unequivocal evidence on record that so interview board acted in a particular manner with the intention of it acted with the intention that the petitioner is held not suitable for the promotion, etc. And then I have already pointed out, look at the track record, 2004 onwards till 2018, the 5 promotions. Here at 2022 only the problem arose because it's a higher managerial post. Certain factors were needed to be looked into very deeply. As it was felt that at that very point of time, petitioner did not act in a manner befitting of holding a higher position of managerial responsibility. So, my lord, this is in connection with interview board acting arbitrarily, not awarding marks under separate head, etc. Now, my lord, I will deal with the second line of argument. The second argument is, my lord, that the marks is scored in performance appraisal report. Performance appraisal report, my lord, has seen has total 60 marks. Out of 60, I think the petitioner got 56, if I remember correctly, in the mark sheet. He got very high marks in PAR. So the argument is, performance appraisal report has so many factors are looked into by in the performance appraisal report. So those factors can certainly be lifted and brought into picture here in the interview. You can very well give him marks as per the PAR. So the marks scored in performance appraisal report according to petitioner ought to have been the basis for giving him marks in the interview. On this, my lord, I will point out the relevant paragraphs of our counter affidavit, what we have argued. The relevant paragraphs, my lord, in the counter affidavit are our counter affidavit against their writ petition. 4 paragraphs I will read, my lord. Para 17C, D, E, and F. Para 17C, D, E, and F. From page 247 to page 250. There are 3 pages.
Page
Page 247 to 250. It has 3 relevant paragraphs in connection with this argument. 17C, D, E, and F. I begin with para 17C at page 247. The contents of paragraph 17C of the writ petition are incorrect and are accordingly denied. It is denied that at least 10 out of 12 different aspects appearing in clause 10.5 of the promotion policy and rules for NSPC executives amended on January 29, 2022 can be related to the marks taken into consideration against different categories under the 4 different heads, quote unquote, key performance area 75 marks, competency 15 marks, value 5 marks, and potential 5 marks, as well as comments in the attribute integrity and remarks in the awarding final marks in par of the incumbent. The DPC, after considering all the above aspects, including those provided in clause 10.5 of the departmental promotion policy, has awarded marks as per performance in the interview and did not recommend the petitioner's name for promotion to the next higher grade. The contents of paragraph 17D of the petition are incorrect, misleading, and are accordingly denied unless specifically admitted hereinafter. While it is not denied that the DPC can award a maximum of 15 marks in the interview, and while doing so, 12 aspects referred to in clause 10.5 are to be considered. However, it is denied that there was absence of any specific question, stroke discussion with regard to the 12 aspects. This was the pleaded case. In the writ petition, they pleaded that no specific question was asked. We have denied it. Questions were asked. This is what we say. Now, difficulty, my lord, is there is no videography as such. Rules don't require it. So that is why, we have to trust the interview board. Not that, we can cast aspersion and say they are not fair with me. It is denied that the petitioner had any opportunity to be under the impression that the DPC took into consideration the marks secured by the petitioner in the par against the 10 aspects. It is denied that the other 2 aspects were to be assessed based upon records available against the petitioner. It is denied that the petitioner scored high marks in the 10 aspects under his par. It is clarified that criteria mentioned in clause 10.5 was taken into consideration at the time of the interview and relevant questions regarding the same were raised to the petitioner. However, the petitioner miserably failed in his interview and could not obtain minimum qualification marks to be considered for promotion. It is denied that the 12 factors were not assessed individually. It is denied that the marks awarded to the petitioner against those factors were to be marked individually for them to be discernible. It is denied that it is not clear as to on what basis the DPC awarded 6 failing disqualifying marks out of 15 in favor of the petitioner in the interview. It is reiterated that the marks awarded to the petitioner was on the basis of the petitioner's performance in the interview. It is denied that any reasonable person would award more than 6 marks out of 15 in case of an incumbent who had secured 56 out of 60 in the marks awarded for last 5 years PAR. It is denied that the DPC were required to record in writing in case something bad had transpired in the interview. Pausing here, I submit one thing. I ask myself, if par is to be the basis, then what is the requirement of the interview? Then computer is enough. You put the data of par in the computer. Computer will give you the result. This person is fit for promotion. Apparently, my lord, the interview is necessary to judge the human qualities of a person. Because we are interviewing a person for the purpose of a managerial position. Apparently, my lord, the qualities that are required to be a good manager at a higher level in a big organization, those very qualities can only be ascertained by the members of the interview board by asking questions to the gentleman, looking at his demeanor, his physical appearance, his presence, and the manner in which he conducts himself before the board. Otherwise, par by itself is enough. Here, in the Honorable High Court also, judicial officers are interviewed for the purpose of promotion. We can look into their SCR. That is good enough. You promote a person looking at the SCR. What for do we interview them? I ask myself. The purpose is to ascertain what qualities he is having, how he will perform. Does he have that managerial ability? How he is conducting himself? Those are the human aspects which cannot be reflected in a par. And more so, par is written by one individual. Reporting authority, accepting authority. That is the end of the matter. There is a reviewing authority. And we all know it's year by year basis. So many things go into that. Interview board, you appear, you conduct, you perform, you satisfy them, your human qualities are looked into, ascertained, and marks are enough. And in any case, the rules don't say that. The rules don't permit. We are abiding by the rules. One may then very well question that rules should not permit interview at all. The rule should say that only on the basis of marks obtained in the par one should be given promotion. The rules don't say so. And rules are not under challenge. In any case. Then another para. The para 17E at page 249. It is denied that there were no discussion, stroke questions regarding the criteria mentioned in clause 10.5 of the department promotion policy. It is denied that the DPC could not have taken a completely adverse view against the petitioner in respect of those 12 aspects, which was in direct conflict to the marks awarded in par of the petitioners for the year 2016-17, 17-18, 18-19, 19-20, and 20-21 against the attributes referred to in paragraph 17C above. It is pertinent to state that marks awarded in interview are with respect to the performance of the candidate during the interview process. I emphasis upon this very sentence. Marks awarded in interview are with respect to the performance of the candidate during the interview process, and the marks awarded in the power of the petitioner have no bearing on the marks awarded to the petitioner. It is denied that the DPC has acted in violation of clause 10.5 of the department promotion policy. It is denied that the 6 marks awarded in favor of the petitioner out of 15 marks is prima facie based upon biased and arbitrary appreciation of the materials before the DPC and needs to be set aside and quashed for the ends of justice. Without prejudice to the fact that the interview process was conducted in a completely fair and unbiased manner without any arbitrariness, it is submitted that the decision of the DPC regarding the merits of the candidate is not amenable to. On this, my lord, I will advance, my lord, further arguments. There are judgments on that subject. The scope of judicial review, when my lord would look into the selection committee's recommendations. So that is it, my lord, on this aspect of power. And my lord would also remember that the interview was conducted by 6-member DPC. There was one external monitor, and they were all senior officials. So, my lord, primarily, these were the two grounds which were urged by the petitioner in his argument. But I have seen in the pleadings, there are a couple of other grounds. Sorry, one more ground was urged. It was emphasized that I must satisfy your lordship. The third argument was that the promotion of 5 managers, they're all private respondents here. Promotion of 5 managers civil who did not meet requirement prescribed under clause 12.8, that is, my lord, requirement of 4 years of field experience at the level of E2 to E5. So field exposure was essential. And those 5 managers civil, even though they did not fulfill the requirement of 4 years of field experience, were given the promotion.
Yes.
Now, on this, my lord, I'll once again, first of all, I will read clause 12.8 first of the promotion policy, dealing with this aspect. 12.8.
Twelve point.
12.8. It deals with the field exposure. I read, my lord.
Yes.
Field exposure is essential for consideration of promotion to the grade of E5, E6, E7, and E8. In the present case, my lord, we are dealing with E5 to E6. Thus, an executive will be required to have field experience at project, power station, unit, office, field, other than posting at corporate office, all regional offices, NHDC office Bhopal, such and such, CVPPL, office Jammu and liaison offices for consideration of promotion as follows. In the case for promotion to the grade of E6, from E5 to E6, my lord, minimum of 4 years experience at the level of E2 to E5. In the case of the petitioner, my lord, he had the requisite 4 year, he had requisite experience, and he was given 10 out of 10. Full marks he got. Now, allegation is there were 5 others who did not have this requisite experience. Even then they were promoted. The answer lies, my lord, in the 3 sub-paras below the chart. That I am reading, my lord. Where the executive does not have sufficient exposure at the time of consideration of promotion, as stipulated above, the executive shall necessarily be transferred to the field for exposure, and promotion will be effective only on joining at the new place of posting. So, my lord, in a case where the requisite field exposure is not there, the person concerned who has been found suitable, my lord, first of all, he will be given the field posting. And his promotion will be effective only on joining at the new place of posting. This is what the rule says. This is the first exemption. The second is where executive does not join at the new place of posting in the field on promotion within the stipulated period, the promotion would stand automatically cancelled and his case for promotion to the next higher grade will be considered afresh by the next DPC as per policy. To counter operational difficulties, and this is the last exception, my lord, to counter operational difficulties in implementing the clause relating to field exposure for few key functions such as design and engineering division, company secretariat, cadre, etc. Exceptions, if required, may be made after approval of CMD by recording proper reasons. I'm sorry, this kind of a disturbance. I'm sorry, my lord. Please. I don't know. I normally take care of switching off the phone. How come? This time I forgot. So, my lord, those who don't have requisite experience, in their case, their promotion will be effective only when they join at the new place of posting. That will be the field posting on promotion. They will be given that. That is the first. And lastly, an exception is provided that there may be certain operational issues if we send person to field posting, those who are suitable for promotion. In the case of those operational difficulties, reasons will be recorded and approval of the CMD will be taken. Now, my lord, the question I would be asking myself is whether in the case of those 5 executives, examples of which have been given and who have been made parties over here, whether in that very particular case, we have followed this procedure or not. The answer is affirmative, yes, we have followed this procedure. Now I'll come to the relevant paragraphs of our counter. We have given the lectures and we have given the explanation. I'll take my lord to page 243 of my counter affidavit. Page 243 of the counter affidavit, para 12.
Yes.
My lord, the relevant portion would be 5th line from the bottom at page 243. 5th line. Regarding the petitioner's averment. I hope my lord has got it. Yes. Regarding the petitioner's averment, that only 7 executives who were promoted from the cadre of manager civil E5 to senior manager civil E6 met the requisite minimum 4 years experience at the level of E2 to E5 with regard to field exposure for promotion from the cadre of manager civil E5 to senior manager civil E6. It is submitted that clause 12.9 of the departmental promotion policy itself provides that in case the executives do not have a necessary field exposure at the time of consideration of promotion, such candidates shall be transferred to the field for exposure and the promotion shall be effective only after joining at the new place of posting. Further, clause 12.9 itself provides that in special cases, the competent authority can exempt the requirement for field posting post-promotion as well. Thus, it is patently clear that not having sufficient field exposure at the time of consideration for promotion was not a bar for promotion, as sought to be contended by the petitioner. The contents of the rest of the paragraph merits no response, except to state that the information sought by the petitioner under the RTI Act is exempt from such and such, not relevant. Then, my lord, the next is page 237. 237. Paragraph 20. Again, because preliminary submission in the paragraph applies, so that's why, my lord, this numbering, my lord, appears a bit odd. Para 20, the petitioner has also made other baseless allegations regarding the promotion process, including that the promoted candidates were not eligible for promotion due to lack of necessary field exposure. In this regard, it is stated that the clause 12.9 of the departmental promotion policy itself provides that in case the executives do not have a necessary field exposure at the time of consideration of promotion, such candidate shall be transferred to the field for exposure and the promotion shall be effective only after joining at the new place of posting. Thus, it is evident that not having sufficient exposure at the time of consideration for promotion was not a bar for promotion, as sought to be contended by the petitioner. All candidates who were promoted in the absence of the requisite field exposure were given field postings immediately upon promotion. In this regard, it is stated that respondents number 6, 7, and 9 have been transferred by clause 12.9 of the departmental promotion policy. Respondent number 8 and 12 are already in field posting, and respondent number 5 has been retained with the approval of competent authority in terms of clause 12.9 of the departmental promotion policy. My Lordship may kindly turn to annexure R2 at page 264. It is in respect of respondent number 5 who was retained with the approval of the competent authority because of operational necessities. Page 264. At page 264, recently interviews have been conducted for promotion from manager to senior manager, wherein following officers of PMSG, IT, IAS division have also given their interviews for consideration for promotion to senior manager. However, these officers have not completed minimum period of field posting in terms of clause 12.92 as amended by order number such and such of promotion policy, which stipulates that minimum period of 4 years of field exposure at E2 to E5 level is required for promotion from E5 to E6 grade level. In this regard, it is to submit that in case these officers are promoted, they will have to be mandatorily transferred to field station for completion of field exposure in terms of aforesaid clauses. However, presently, services of these officers is essentially required at their present place. So, my lord, the operational requirement has been emphasized here. However, presently, services of these officers is essentially required at their present place of posting, and it may not be in the interest of corporation to transfer them at this crucial stage. Srimati such and such is looking after works of Parvati 2, Seva 2, and documents related to parliamentary queries, which are time bound, and her services may not be dispensed with presently. Such and such is engaged in critical works of cyber security and network, and do not presently have replacement, and this aspect being directly monitored by Ministry of Power, it may not be prudent to transfer him presently. Shri Manoj Kumar such and such is engaged in critical works of EMS division and involved with coordinating with district authorities, and his services are essentially required in EMS division. As per clause 12.9 of promotion policy, to counter operational difficulties in implementing the clause relating to field exposure for few key locations such as D&E division, CS cadre, etc., exceptions if required may be made with the approval of CMD by recording proper reasons. In view of exigencies of work as explained above, it is proposed that clause relating to field exposure in case of above officers are considered for promotion may kindly be considered for exemption, and they may be retained at the current place of posting presently, submitted for kind approval of CMD such and such. CMD without approval is given here. Routed through officers, finally, there is an approval of CMD. Mahaprabhantak, such and such, the last signature. So, without reasons have been given. Likewise, my lord, the last annexure at page 266. Those who did not have the requisite field exposure at the time of promotion, they were all given the field postings, posting details. This is 5.2. So details of postings have been given here in these pages of these officers. R13. 5, 6, 7, 8, 9, and 12. Details are, my lord, respondent 8 and 12. They are already in field posting after promotion. Respondent 6, 7, and 9, they were transferred under clause 12.9 of departmental promotion policy. And respondent 5 was retained with the approval of competent authority. So that is not those who did not have the field exposure, they were given the field posting. The lordship has seen the reasons. Detailed reasons have been given. So, my lord, this is my reply to the third argument. that there were certain officers who were shown a special favor in violation of the promotion policy is incorrect.
Yes.
Now, my lord, there are certain pleadings, but then this is not, this was not argued. So I don't know if they don't press this point. Otherwise, if necessary, my lord, I will give my replies in the whatever written argument I give, I may cover this up. Namely, so far as constitution of DPC is concerned, one of the argument in the pleading is as to why DPC was constituted in February 2022. Why not in April? Answer is very simple. Number one, it doesn't prejudice the petitioner. It was constituted in February 22, but was brought into effect only in the month of April. Since it was brought into effect only in the month of April, that is why petitioner could be qualified and could face the DPC, because it was only in April 2022 he completed 4 years of qualifying service. So it's neither here nor there, this kind of an argument. So there is nothing much in it. Then the second argument was in respect of the composition of DPC. This was not argued. It is in the pleadings, but they have not argued it. I have already given a reply. I have shown the composition. The composition, my lord, is very much in conformity with clause 4 and annexure 4, which I have shown to your lordship. If necessary, my lord, I will provide the names also with their particulars and details in my written argument. Then, my lord, lastly, the last argument, this was argued, of course, that the marks for PG diploma not given. I will place before your lordship the reasons given by the NHPC. Right or wrong, my lord will decide, but my submission, my lord, on this aspect is going to be that even if 1 mark for PG diploma been given to the petitioner, it would have made no material difference to his case. From 72, he would have got 73 marks. Whether he gets 72 or 73 makes no difference, because in any case, he would have been higher up in the merit, 5 or 6. The difficulty is additional mark for PG, additional 1 mark for PG cannot be included in the marks, in the 6 marks given to him by the interview board. The 6 will remain 6. He requires 8. 6 cannot become 7. This is my submission. Of course, my lord, the answer given by the NHPC in its affidavit is, and my lord may not find it adequately satisfactory. Namely, NHPC says, well, you ought to have given the certificate. You did not give the certificate, you gave the mark sheet. I will take it. Mark sheet may be good enough. Why do you require a certificate? But finally, the answer is, fine, even if you get 1 marks additional, that marks is added into your merit, your total marks become 73. But your interview marks remain 6. And therefore, you remain unsuitable. That is the core of the issue. So it hardly makes any difference. And lastly, my lord, I will place one judgment on the scope of judicial review in these matters. Prima facie, I have satisfied your lordship. Why prima facie, my lord? I have established, in fact, that there is no deviation from the rule. Rule has been strictly followed. We have followed promotion policy in letter as well as in spirit. Now, in a case, my lord, where there is no apparent violation of the promotion policy, the 6-member interview board has acted impartially, has given reasons also for the manner in which it conducted itself. What is the scope of judicial review in a matter of selection? The judgment I will refer to is 2023 SEC online. I have one extra copy. I'll give it to your lordship. (2023) SEC online, SC 344. It is Tajveer Singh Sodhi versus the state of Jammu and Kashmir. There are 3 paragraphs, my lord, I will rely on. Para 65, 66, and 67. Para 65, I read first. Before proceeding further, I'm sorry. Para 65.
Yes.
Before proceeding further, it is necessary to preface our judgment with the view that courts in India generally avoid interfering in the selection process of public employment, recognizing the importance of maintaining the autonomy and integrity of the selection process. The courts recognize that the process of selection involves a high degree of expertise and discretion, and that is not appropriate for courts to substitute their judgment for that of a selection committee. It would be indeed treading on a thin ice for us if we were to venture into reviewing the decision of experts who form a part of a selection board. The law on the scope and extent of judicial review of a selection process and results thereof may be understood on consideration of the following case law. Case laws have been referred to. I'll refer to two only here. They have referred to initially the Dalpat Abbas Aap Tolunke, 1991 SEC page 305, and para 9 of this judgment has been quoted. It is needless to emphasize that it is not the function of the court to hear appeals over the decisions of the selection committee and to scrutinize the relative merits of the candidates. Whether the candidate is fit for a particular post or not has to be decided by the duly constituted selection committee, which has the expertise on the subject. The court has no such expertise. The decision of the selection committee can be interfered with only on limited ground, such as illegality or patent material irregularity in the constitution of the committee or its procedure vitiating the selection or proved malafide, affecting the selection, etc. So, my lord, the principles are: number one is illegality or patent material irregularity in the constitution of selection committee. Is illegally constituted. That is not their case. They could not demonstrate that. Second, procedure vitiating the selection. I asked myself, what was wrong with the procedure? We followed the procedure outlined in the promotion policy. And thirdly, proved malafide, affecting the selection. That is not established either. So, my lord, the scope of judicial review, the essential grounds on which the recommendation of the interview board could be assailed are missing in this case. Then, my lord, in a similar vein, the court further says, in Secretary Health such and such versus Dr. Anita Puri, this court observed as regards the sanctity of a selection process and the grounds on which the results thereof may be interfered with. Para 9 is quoted of this case. It is too well settled that when a selection is made by an expert body like the Public Service Commission, which is also advised by experts having technical experience and high academic qualification in the field for which the selection is to be made, the court should be slow to interfere with the opinion expressed by experts unless allegations of malafide are made and established. It would be prudent and safe for the courts to leave the decisions on such matters to the experts who are more familiar with the problems they face than the courts. It is the expert body, if the expert body considers suitability of a candidate for a specified post, after giving due consideration to all the relevant factors, then the court should not ordinarily interfere with such selection and evaluation. That is my case. All the factors looked into. The 6-member interview board formed an opinion that here is a man who is not suitable for promotion. And he was given 6 marks, which is 2 less than the minimum qualifying 8 marks. Then same principle, my lord, was reiterated in MB Thimaiya versus UPSC. They have quoted. Then lastly, my lord, I will refer to 2 paragraphs, paragraph 66 and paragraph 67. I read 66. Thus, the inexorable conclusion that can be drawn is that it is not within the domain of the courts exercising the powers of judicial review to enter into the merits of a selection process, a task which is the prerogative of and is within the expert domain of a selection committee. Subject, of course, to a caveat that if there are proven allegations of malfeasance or violation of statutory rules, only in such cases of inherent arbitrariness can the courts intervene. Without pausing here, I ask myself, could they make out a case of inherent arbitrariness or malfeasance or violation of statutory rules? The answer is no, they could not. Then para 67. The courts, while exercising the power of judicial review, cannot step into the shoes of the selection committee or assume an appellate role to examine whether the marks awarded by the selection committee in the Viva was are excessive and not corresponding to their performance in such test. The assessment and evaluation of the performance of candidates appearing before the selection committee, stroke interview board, should be best left to the members of the committee. In light of the position that a court cannot sit in appeal against the decision taken pursuant to a reasonably sound selection process, the following grounds raised by the writ petitioners, which are based on an attack of subjective criteria employed by the selection board interview panel in assessing the suitability of candidates, namely that the candidates who had done their post-graduation had been awarded 10 marks, and in the Viva was such PG candidates had been granted either 18 marks or 20 marks out of 20, that although the writ petitioners had performed exceptionally well in the interview, the authorities had acted in an arbitrary manner while carrying out the selection process would not hold any water. So, my lord, I rest my submission here. My submission is that the grounds urged by them are beyond the scope of judicial review, on which, my lord, they could assail the recommendation of the interview board. Now, my lord, it was also urged as to how come all those who could not qualify, because 12 qualified out of 24, only 12 could be promoted. Lordship has seen the marks of 12. All the 12, my lord, they got minimum qualifying marks for the interview, 8 or 8 plus. The rest 12 could not make it. Now, how come those who did not qualify were not found suitable? All of them were given only 6 marks. My lord, the answer is simple. Once members of the board are satisfied, you are not making it. You are not crossing the bar. It is like a bar. 8 is a bar. The moment I see you are not crossing a bar, the moment you touch 8 or above, I have to be very, very guarded and careful in giving you mark, because that would go into the relative merit. Who will be senior, who will be junior, who will be higher up in the merit. The moment I am satisfied you are not making a bar, you are not attaining the kind of ability which is needed for the purpose of touching that bar of 8. My lord, one may not be so guarded and so careful, I don't know. In any case, my lord, why get 6, why not 6.5, why not 7 is something which is beyond the scope of judicial review. As to why did they give 6, maybe all of them, broadly speaking, the members of the board thought they are not making it. They are not crossing the bar. Give them 6, only 6 would be okay. Because the moment you don't make a bar, whether you got 7.5, you get 6 or you get 6.5 is irrelevant. What matters is whether you make it or not. The moment you touch 8, it becomes extremely important how you are evaluated. Whether you should be given 9 or 10 or 11 or 12. But the moment you are below 8, it hardly matters. You are not making it, you don't touch the bar. Maybe members of the board said all of them are not making it, and somehow, more or less, broadly speaking, they are all alike. Give them only 6, not more. They don't deserve more. In any case, my lord, I ask myself, is this within the scope of judicial review? Could my lord enter into the frame of mind of those members of the interview board and determine as to why 6, why not 7, why not 7.5? My humble submission is my lord would not venture into such a scrutiny under Article 226. That's my humble submission for consideration of my lord. So, my lord, that is it. I rest my case here. These are the broadly, these were the grounds urged by them. And I have given my answers with the relevant case laws. And, my lord, if necessary, my lord, I will give the written argument, because considering there are so many, my lord, clauses of promotion policy to be referred to, etc. So, for the convenience of your lordship, my lord, I will give the written argument on this. Whatever I have argued will be there in my write-up. So, my lord, highly obliged.
Also with regard to the private respondents, Lord, oh,
Arguments of the
private
private
respondents, I was not aware. Who represents them?
My lord, nobody. I don't think they have. Have they?
Was there any representation?
Lordship, they are private.
No. What they represented?
My lord, I am not aware so far as private respondents are concerned.
Advocates for the private respondent.
Is their name reflected?
They should come.
This is applicable.
You know, I have done my job for the organization on whose behalf I am appearing. It is up to the concerned advocate of the private respondents.
T.T. Nair, Chetri. Are they appearing or not? Will you be giving a reply?
Lordship will be giving a rejoinder lordship, not today lordship, any date next week lordship. for reply.
Next week, this court is not.
Lordship.
I'm not sitting.
The lordship will be
For-
next available lordship.
I'll be in the last week of June.
Last week, any date last week of June, lordship.
And my lord, so far as my lord, we the respondents are concerned, we don't have any further right of reply as such. But if there is any specific query from this honorable court, then my lord, certainly I will come and explain. Otherwise, my lord, written argument will be filed before your lordship after the conclusion of hearing.
But Mr. N. Gaudam,
Lordship.
then a counsel for the petition. Also had Mr. B.K. Dewari, then a senior counsel, assisted by A.R. Gowai, then a counsel for the respondents. 2 to 4. None appears for the respondents. 5 to 16. Correct. Is it 5 to 16? And the place for the private exchange. Am I correct? 5 to 16. Departmental Promotion Committee. This also, I think
Yes,
you.
law I'm appearing. For DPC I'm appearing. That is interview board.
That's, we get you, it's just person for the standards, 2 to 4. And 70. None appears. List the matter for further hearing, when shall we have it?
Lordship, when lordship is next available. Your Lordship.
It will be last week of June, because 2 weeks I'm out
Lordship.
as per the rooster.
Lordship.
I don't know, last week, whether it will be a miscellaneous week, would it be a, would it
There is
be a
motion is
motion
there,
week?
but there's no bar lordship
Okay,
or part third matter to be operated.
we have it on 25th then. If
And
it's
my
not
lord,
supposing
because my lord, I have no right of reply as such.
If it
I'll-
spills out, then we can take up on 27th.
Lordship.
As my lord pleases, because I have no right of reply as such. I'll come only when my lord requires my presence for some specific query.
Lordship.
Otherwise, written
Meantime,
arguments are there.
If you catch all of these councils, you
Lordship.
just inform.
I'll inform you.
And my lord, lastly, written arguments we will give, as I have already informed.
And you can prepare your written arguments.
Lordship, we will submit this.
Date. No, 25th.
45, 46.
Let's take up at 2 o'clock.
Wait,
That's
please.
fine. Yes, sir.
And today, just a little while ago, I've been served with a copy of affidavit indicating the purported reasons. And those reasons are neither relevant, adequate, or logical. To that effect, my lord, I'd like to file a counter. In any case, I think that has not come on record today. Just now filed.
Okay.
So, my
Uh,
lord,
1 minute. Mr. P.G. Fukan, and his son in counsel, Guwahati University,
Yes.
submits that he has filed an additional affidavit.
An additional affidavit.
Additional affidavit when?
Today itself.
just little while ago.
This morning. Registry to verify and place the same on record. Comma I found in order. Mr. A.K. Barwa, the counsel for the petitioner, prays for.
My lord, your lordship is not here, I think, next 2 weeks.
Yes.
And the last week might be little burdensome for your lordship because that will be a miscellaneous week. So, my lord, your lordship can immediately have it after the vacation and I'll file my reply in the meantime. my lord.
Okay, prays for 3 weeks time.
Your lordship will say 1 week or 2 weeks.
3 weeks time to file reply to the additional affidavit filed by the Guwahati University.
Well.
List on,
Your lordship can have it on 16th, my lord.
yes.
Well.
16. No, 16.
So, 18th or 12th.
On 25 minute,
25 more cat matter.
25th of June,
23rd, my lord.
23rd
23rd
Tuesday,
of June.
July.
July.
Immediately after vacation, my lord.
Or your lordship can have it on 16th or 18th,
Not 16 or 18, my lord. I will have some difficulty there. Then
17th,
23 will be better for us.
17th or 23th.
Okay, 23rd July.
Obliged.
Most of them.
Mr. Okay, Baral, Constable, the press for 2 weeks time.
2 weeks time.
Not 3 weeks. Prayers allowed on the press with parties. Mr. Metro. 20. You want it on 20?
23, my lord.
23.
3rd July.
Obliged.
Pick up the IA, my lord.
Yes.
If your lordship will see the last order, my lord,
Hmm.
last order, there was a specific direction to the BTC, my lord, to file an affidavit. If your lordship will see para number 5,
Now, have you filed a
Well,
affidavit?
I have got certain instruction to find a down, but the full details are not there. Now I have got the full details of all the post, my lord. I just hand over.
No, you're supposed to file an affidavit.
Man, I'm
written
supposed to,
on-
but it had to be very detailed one.
Yeah, detailed
Detailed
affidavit.
one, because that detail was not
Have you
available.
got
Okay,
it?
that detail was not available. But what had happened is that initially 10009 posts were sanctioned. They were all accommodated. Subsequently, in the last part of December 2023, 1216 posts were sanctioned. Man. And there are 13 or 14 persons are there that needs to be accommodated from the petitioners. And that process is on to accommodate this petition. In the meantime, that we got the sanction. And then the IA came up. IA came up to circumvent that our process to get these persons appointed in a sanction post. Now the IA has come up. My lord, I am going to file an objection to the IA also, my lord. And another petitioner has
That is-
already.
IA does a different thing now. What we are concerned today is the order passed by this
No,
court
no,
in the last
No,
occasion,
last occasion order was passed.
giving you a specific direction to file your affidavit,
My lord,
along giving details.
details was not furnished, my lord, because now the details has come. How many LP, ME teacher will be accommodated? Lordship will find that.
So you have a total of how many petitioners are there? 314.
421 petitioners are. Actually, Lordship, it is like this. May I just, Lordships, so permit? Initially, this case, which Lordships have also passed orders, Lordships have had the occasion to handle this case.
I
earlier.
remember.
Now the case was that if Lordship will kindly see Lordship's own order passed on 2nd of August 2022. It will clarify the whole position and how this implement application is now a misadventure to scuttle the whole process. Please, Lordship, see your Lordship's order of 2nd of August 2022. Because we are proceeding in the right direction, then the IA came to scuttle all this.
As who filed the IA?
IA is them. So today the petitioners and the BTC are added in that we do not want these people to be implemented at this stage. Because then the whole cause of action will change. So to that extent, they and us are on the sailing in the same boat. That there should not be an implement at this stage. If I'm. I support that. To that extent. So let's please see the order dated 2nd of August 2022.
2nd of August, passed in which petition?
In this,
In the matter-
in these matters only.
Hmm?
In these matters only.
In this IA?
Not I. It will be writ petition. If I can hand over that order. Yes, order. Collective order person. এইখন তো order দেখা নাই নাকি? এইখন order. তিনটা মাইকে। The IA minor, there are 241 petitions. 241 petitions. I'm sorry that we had this copy, the cause title is missing, but the order is there. 28/2022, that's an order passed by Lordships. Here Lordships says the entire thing. May I read it? Yes. So therefore, Lordship had understood that time Lordship was concerned about the fact that these people, even though working from 2015, is not getting their salaries. The position remains the same till today. What is going on?
My lord, what happened?
So therefore, I tell you,
These persons were illegally appointed, they file a writ petition, bunch of writ petitions are there. That was.
everything has been
No, no, now, what had happened, my lord? Now these petitioner were appointed in a non-sanctioned post. And that's, since they're a non-sanctioned post, the finance is not a subject matter of the BTC, that had to be sanctioned. We even tried it to give it in a SOPD fund also, and went to the finance department. That was also not entertained, my lord. And because finance is not within the domain of the BTC, my lord. Now another 1216 posts has come. Now we are making a process to accommodate these persons. That process is on because it was held up because of the model code of conduct.
Okay.
Now, my lord, in the meantime, that funny, I have finding the one sheet of paper, my lord.
What my colleague is saying, these are as Lordship is passed. Now the sanction has come,
Yes.
financial grant has come, he'll accept that is recorded by Lordship in the subsequent orders. Now where is the question of holding back our salaries? It's a human
Now-
issue, Lordship. 2015, since today we are almost 10 years down the line. We are working without salaries. Now the sanction has come, grant has
Yes,
come.
it will come.
Yes, come. So now why are they not
Sanction has
releasing the
come, now
salaries?
300, we have separated out at 314%, sir, they will be accommodated. Now the orders will be coming, my lord, because of all this model code of conduct till 4th, my lord, that's why we have not processed.
How is model code of-
Now the model code is not there, it will be processed and within a few.
No, I'll do one thing. Since you said that you have got a detailed
Yes, yes.
status,
Yeah, details status.
I'll give you 2 days time to file affidavit.
No, Lordship will give me 4 days, because it is from BTC, my lord. I need at least 4 days time, my lord.
I'll give you 4 days time.
Lordship.
I'll get it listed, fix it next week.
Lordship,
Then we'll consider it.
Lordship.
And in the meantime, Lordship's improvement last
No,
occasion
implement I have
also.
also objection, my lord.
That if you want to file your objections, you are
No,
free to
it
file.
has no bearing, Lordship. Even last time it was extensively argued, but the court declined to issue notice. The court understood. So therefore, there is no question of implement at this stage.
Well, implement will scuttle the entire process, my lord.
I heard the learned counsel for the Stop. Para. Mr. S. Boral, then the standing counsel
BTC.
BTC submits that pursuant to the order dated 14/5/2024 passed by this court, comma, he has received the detailed instructions and prays for 4 days time to file affidavit. Stop. I'm passing a short order only. The prayers allowed. When do you want? Next week?
Next week, let it be on 13th, my lord.
Yes, 13th.
13th.
Is it okay?
Yes, I am now in some
List the
vacation.
maximum. You can take back this.
Yes, exactly. I'm sorry. Lordship may indicate the order that on the next occasion, some orders with respect to our salaries will be passed because. No, Lordship may
the-
indicate so.
Consideration for payment of the current salary to the petitioners. I'll say current, not the areas.
Yes, let the current
Shall be
salaries.
considered on the next week.
Wait,
Okay.
wait.
Admission.
What is this case? You file your reply?
Yes, ma'am.
Who was appearing for the other side? Gupta.
Mr. Gupta was there. But if the reply is not there, I have got the extra copy of the reply. Issue is that, my lord, the petitioner before lordship has been denied.
You appearing?
H. Gupta is here. He was here right here. H. Gupta sir is preparing.
He'll come.
He'll come.
When did you file your reply?
On 4th, my lord. 4/6.
they have stated before lordship that
You've got a reply?
My lord.
Okay.
their submission was that the adverse remarks were communicated to the petitioner, not the adverse ACRs. Adverse remarks were communicated to the petitioner. What they have communicated, I have brought on record at page 274.
Yes.
274. This is the communication by which, my lord, they have stated that, my lord, this is the remarks given by the IO and RO, and this has been communicated. This was communicated to the petitioner. Not a single page of the ACR was communicated. Not even the gradings. Only the remarks were communicated. And moreover, my lord, the remarks of the accepting officer, is the final remarks. And that was not communicated to the petitioner. If the remarks of the IO and RO, initiating officer and reviewing officer is upgraded, even expunged, the remarks of the accepting officer remarks remain the same. That will have no bearing on the upgradation of the remarks of the IO and RO, because accepting officer is the final authority whose remarks is the final. So, my lord, communication of these remarks has no bearing on the upgradation of the ACR.
You're saying this was communication.
Yes, ma'am.
Yes.
If you lordship stand to the remarks given by the accepting officer, lordship will find
Where is the accepting officer's remarks?
the remarks. Page 79, page 79 of the writ petition, my lord. Page 79.
No. What is 275?
275 is the, my lord, communication of the second ACR, my lord. Second remarks of the IO. Only the gradings given by the IO was communicated in the second ACR. Initiating officer. That too, the remarks of the IO was communicated to the petitioner after the ACR was completed by the RO and AO. RO has reviewed the ACR, accepting officer has accepted the ACR. Thereafter, gradings of the IO was communicated to the petitioner. That will have no bearing on the ACR. Even if the remarks of the IO is upgraded, we will kindly see the dates. In the first ACR, they have communicated the remarks on 11th of August 2006. That note, lordship may kindly note. 11th of August 2006. The remarks given by the IO and RO. Page 274, my lord. Down below, my lord. I have received it, my lord, on 11th of August 2006.
Okay. This is for period?
For the period, my lord, 14/5/2005 to 9/1/2006.
Yes.
This was, lordship kindly turn to 79. Page 79 is the, remarks of the accepting officer.
Page?
Page 79. 79, my lord.
Of the writ petition?
Yes, my lord. 79.
Yes.
Down below, lordship will find 25th July 2006. left hand side, my lord.
Hmm.
25th July 2006. This is the remarks given by the accepting officer. After remarks given by the accepting officer on July 2006, what was the purpose of communicating the adverse remarks given by the IO and RO in the month of August? By what time, my lord, already the ACR was completed?
Yes.
The next period, my lord, also will find page 275. 275.
Hmm.
This is the remarks. Only the gradings given by the IO was communicated along with this communication, my lord. Plus you'll find the gradings given by the IO at page 276, my lord. The RO column is not filled up. Two 76. Only the gradings given by the IO was communicated.
That is adverse remark of April 2006 to 31st March.
Yes, my lord.
Correct.
Yes, my lord. IO has endorsed his remarks on, my lord, 18th of May 2007.
It was communicated to you on
11th of June 2007.
yes.
Now, let me turn to page, my lord, 295. 295.
Hmm.
This was the remarks given by the RO. For a losses kind information, my lord, I am this ACR, my lord, sought for, my lord, the information in the of the ACR under RTI Act, my lord, I applied for information. They have given the ACR, but not the counseling letters. They have stated to have been counseled. Those letters were not included along with the ACR, my lord. Even when, my lord, I sought for the information on the RTI Act. But in this ACR, they have, my lord, the RO has endorsed his remarks on 25th of March 2006. 25th of March 2006. Page 295.
Yes.
Down below, also you'll find 25th of March 2006. And the accepting officer I'm sorry, madam, this is the other essay, madam. Page 300. Second ACR, madam. Second ACR, also you'll find. Yes.
This from which period to which period?
Second ACR is, madam, for the period 1st of April 2006 to 31st March 2007. IO endorsed his remarks on 18th of May 2007, page 305. 305, my.
Hmm.
18th of May. Possible got it, madam. And RO on 22nd May 2007. Next page, my lord, 306. 22nd May 2007. And the accepting officer, 25th of May 2007.
How do you know this is the accepting officer?
My lord, column 30 is the, my lord, remarks
Okay.
to be given by the accepting officer. So, my lord, accepting officer has accepted the ACR on 25th of May 2007.
Just another date, 25th June.
I don't know, my lord, why they have put two dates. Maybe for the purpose of, my lord, bringing on record the letter dated 11th of June 2007 under column 31. They have given the other date also, my lord. Initially, it was accepted on 25th of May 2007. Subsequently, my lord, to strengthen their remarks, to bring on record this letter, though it is not within the, my lord, reviewing period, because the period is 1st of April 2006 to 31st of March 2007. This says that I was counseled on 11th of June 2007. It is not within the reporting period, man. It is not within the reporting period. So, my lord, 25th May is the date on which date, my lord, the accepting officer accepted my ACR for that particular period. And it was communicated on, my lord, 11th of June 2007. 11th of June 2007. That too only the remarks given by the IO.
Yes.
The upgradation of the IO's remarks will have no bearing on the final outcome of the ACR. It is the accepting officer whose remarks is to be upgraded. Other two officers are, my lord, initiating and reviewing officers. They are not the final authority. Accepting officer is the final authority which remarks is to be upgraded for upgradation of the ACR. So, my lord, I was not given any opportunity to upgrade my ACR during that communication. And this was not communication of the ACR.
No, what do you mean by not given opportunity?
My lord, remarks of the IO.
The remarks of the IO goes to the RO.
Yes.
RO goes to the AO.
Yes.
Correct.
Already.
After that, it is finalized only it will be communicated to you.
No, man. If after finalization, if it is to be communicated to the petitioner, it is all the remarks of the officers is to be communicated. All the remarks, because all the remarks is to be upgraded, but they have picked and choose the remarks of the IO and RO. They have not given me the remarks of the accepting officer, which is the final authority. Without upgrading the remarks of the accepting officer, ACR will not be upgraded, my lord. Accepting officer is the final authority. If his remarks has to be upgraded, and that was not communicated to the petition. That was not communicated to the petition. So, my lord, communication of the IO and RO will have no bearing on the final outcome of the
SCR, even if those are upgraded on my representation. As the remarks given by the accepting officer was never communicated.
In both the SRs.
In both the SCRs, Malak. In the first SCR, they have communicated the adverse remarks in respect of IO and RO. In the second SCR, they have communicated the adverse remarks given by only the IO, not even the RO.
Okay.
So, Malak, those communications cannot be held to be communication of SCR in proper perspective. I was not given any opportunity to upgrade my SCR during that time. Only after the DPC was held, my SCR was communicated on 8/7/2010. Then only I came to know about the SCR, about the remarks given by the accepting officer and other two officers. So, and DPC was declared on 29/6/2010, and it was communicated on 8/7/2010. So communication is after the holding of the DPC. Then as the Honorable Apex Court held in the case of Abhijit Ghosh Dastidar and subsequent cases, that non-communicated adverse SCRs cannot be considered while considering the cases of promotion. And in my case also, my lord, they have considered the non-communicated adverse SCRs, which should not have been considered, and I was denied promotion on the basis of those non-communicated adverse SCRs.
Yes.
Therefore, my lord, Lordship may direct the authority to promote the petitioner with retrospective effect on the date when his junior were promoted by holding a review DPC. This is my humble submission.
May I please, Malak? Malak, the basic issue, Malak, here is, Malak,
You have not given your reply yet.
reply to the rejoinder, Malak. Okay. Affidavit in opposition we have filed.
I've heard you earlier.
Yes, my lord.
Yes. We have not given I have not given my reply.
Oh, you have not given.
No, no, Malak.
I was just hearing the petition.
Yes, yes.
I think I've heard you. Okay, proceed.
No. You know, the basic issue here is, my lord, what the petitioner has alleged is, my lord, is the non-communication of the, my lord, ACRs, my lord. Here, my lord, the communication of adverse entry is one thing, and, my lord, communication of the below benchmark grading. These are two different things, my lord. These ACRs, adverse remarks are for the period, my lord, 2006. So if I may, my lord, just distinguish between the two, my lord, the communication of the adverse remarks and the communication of the below benchmark grading. These are two different things. And, my lord, the requirement of communicating the below benchmark grading, my lord, came subsequent to the passing of the Devdutt Sharma judgment, my lord, which was subsequent to the, my lord, the ACRs in question. My lord, here the ACR was pertaining to the year 2005, 6 and 6 and 7. So at that point of time, my lord, when the requirement was only to communicate the adverse remarks. And the adverse remarks, my lord, those were duly communicated to the petitioner. Rather, after the communication, my lord, he represented and the authorities have rejected the representation. That is the fact, my lord, which I have brought it by way of an
additional affidavit. And in the additional affidavit, my lord, we have not pleaded anything new because it was at the stage of hearing, my lord. We only bought the necessary documents, my lord, on record. But my lord, now what I find, my lord, that in the rejoinder affidavit which the my lord petitioners have filed, it is a second rejoinder, my lord. But they have changed the little bit of stand, my lord, from non-communication of the ACR to the manner of recording of the ACR, my lord. No, the error, there is an error in manner of recording of the ACR. But the basic point, my lord, what was alleged in the main writ petition is non-communication of the ACR. And in fact, my lord, that non-communication of the ACR was earlier agitated, as my lord knows, before the Itanagar bench, and a direction was given to the authorities, my lord, to consider whether the below benchmark grading can be upgraded or not. That was rejected by the authorities, my lord, and now this is the second round of litigation. So, my lord, coming to the fact of distinction between the below benchmark grading and the, my lord, adverse remarks, my lord, I will take, my lord, to page 244. Page 244, my lord, of my this documents, my lord, which running page 244.
Yes.
Note
OM.
this is the OM, my lord, dated 23 March 2006. If I may read, my lord. This
Yes.
relates to communication of adverse entries, public remarks recorded in the ACR. The undersigned is directed to state that in accordance with the existing instructions of this department, adverse entries, remarks recorded in the ACR of the officials have to be communicated to him for further improvement in his performance, and the official concerned has also an option to make a representation against the adverse remarks within the prescribed time limit. According to the existing instructions, the overall grading in the ACR should, however, not be communicated even when the grading is given below the benchmark prescribed for promotion to the next higher grade. The overall grading recorded in the ACR has also not to be changed in any way, even after expunction of the adverse remarks either fully or partially by the competent authority. The Honorable Supreme Court has declared in its judgment dated 22/11/2005 in Union of India versus Major Bahadur Singh that the judgment of the court dated 31/1/96 in UP Jal Nigam versus Prabhat Chandra and Prabhat Chandra Jain and others has no universal application, and the judgment itself shows that it was intended to be meant only for the employees of UP Jal Nigam. So therefore, my lord, this notification, my lord, I will take, my lord, to another notification thereafter at page, my lord, 49, my lord.
Page
49.
49.
49, my lord. My lord, the notifications are spread here and there, my lord. So page 49. Now that is the notification subsequent to this, my lord. That is dated 14 May 2009. My lord, the subject matter of the office memorandum was maintenance and preparation of the annual performance appraisal reports. My lord, earlier it was called ACRs, my lord. Now it is APAR, my lord. Communication of all entries for fairness and transparency in public administration. If I may read the first paragraph, my lord, the undersigned is directed to invite the attention of the ministries, departments to the existing provisions in regard to preparation and maintenance of the annual confidential reports, which inter alia provide that only adverse remarks should be communicated to the officer reported upon for representation, if any. My lord, in this case, I will show, my lord, the documents by which, my lord, the adverse remarks for the year 2006, 5667 were communicated, the petitioner represented, and the representation was rejected. The Supreme Court has held that in their judgment dated 12/5/2008 in Devdutt versus Union of India, that the object of writing the confidential report and making entries is to give an opportunity
to the public servant to improve the performance. The second Administrative Reforms Commission in their 10th report has also recommended that the performance appraisal system for all services be made more consultative and transparent on the lines of the PAR of all India services. Now, my lord, this, my lord, will note, my lord, the notification is of 14 May 2009. And my lord, the contention of the learned petitioner is that the entire ACR, whether it is good or bad, should ought to have been communicated. That will not hold the field, my lord, because the requirement of doing so came only in the year, my lord, 14/5/2009, and the ACRs at that point of time, my lord, was of year 2006 and 7. So this was the requirement, my lord, in 2009. My lord, the requirement came that, my lord, will see paragraph 2, Roman 2, the full APAR. My lord, now, because earlier it was ACAR, my lord. The full APAR, including the overall grade and assessment of integrity, shall be communicated to the officer after the report is complete with the remarks of the reviewing officer and accepting officer, wherever such system is invoked. Where government has only one supervisory level above him, as in the case of personal staff attached to officers, such communication shall be made after reporting officer has completed the performance assessment. So, my lord, at this point of time, the requirement came, my lord, and my lord will see the next page. This is clause number 5, my lord. This is important. The new system of communicating the entries in the APAR shall be made applicable prospectively, only with effect from the reporting period 2008-9, which is to be initiated after 1st April 2009. So, my lord, that requirement of giving the full ACRs, my lord, was to be effective only after 1st April 2009. And this was the ACR in question, my lord, before lordship, where the petitioner has been given below benchmark of average instead of good, my lord. In respect of 2 periods, my lord, it is below average. So, my lord, that is pertaining to the year 2000, my lord, 5, 6, and 6 and 7. Now, my lord, I take, my lord, to page 51.
So, before the OM of 2009,
Yes,
there was no necessity to give all the
the entire ACR,
entire.
only the adverse remarks. And whether it be IO, RO, or the, my lord, the final authority, accepting authority, whoever has passed the adverse remarks, my lord, that was duly communicated to the petition.
Let us see the page 244 again.
Page 244,
The OM.
my lord. OM dated 28 March 2006. My lord, that clearly says, my lord, that in accordance with the existing instruction of the department, adverse entries of the remarks recorded in the ACR, adverse entries, my lord, oblique remarks recorded in the ACR of the officials have to be communicated to him for further improvement in his performance. And the official concerned also has an option to make a representation against the adverse remarks within the prescribed limit. That was duly complied, my lord. And the 2009 notification, my lord, which I have read, that also affirms the fact that at that point of time, it was only the adverse remarks which was to be communicated. And now, my lord, I will take, my lord, to page.
So when the adverse remarks were entered into the petitioner's ACR for the period 2005.
5, 6, at that point itself, my lord, 6, 7 itself.
That time that OM of 2006 was in.
Yes, yes, my lord.
Yes.
And it was that time itself, my lord, everything was communicated, he represented, and that was rejected. Now, my lord, after so many years, my lord, to find an error in those, my lord, ACRs, my lord, that would be too far-fetched, my lord, because he represented at that point of time itself, 2006.
Where's the representation?
My lord, that is in my my lord, the first representation is there, my lord. My lord will take page 245. Page 245, my lord, is the order rejecting the representation, my lord. Attention of, my lord has got it, page
Yes.
245. It is dated 22 March 2007. Attention of Shri Pankaj Dikshit is hereby invited to his representation dated 8 September 2006. Against adverse oblique remedial remarks endorsed in his ACR for the period 14 May 2005 to 9 January 2006. Shri Pankaj Dikshit is hereby informed that the issue raised by him in his representation have been given due consideration by the competent authority, who has concluded that the representation is devoid of any merit and directs that the same be rejected. And my lord, the representation in respect of this office memorandum is at, my lord, page 274. This is annexed by the, my lord, petitioner themselves, my lord, in their additional rejoinder affidavit. My lord, 274, my lord, will take, that is the representation against which this office memorandum was passed. 274, my lord. My lord, this was the communication of adverse entries, my lord. Page 274. I'm sorry, my lord, this is the communication of adverse, not the representation, my lord. This is the letter by which the adverse entries were communicated, my lord, 19 July 2006. And after communication, my lord, he made a representation on 8 September 2006.
When?
8 September 2006, my lord.
After this?
Yes. 19 July 2006, my lord, he was communicated. He made a representation, my lord, on 8 September 2006, which was rejected, my lord, on 22 March 2007. My lord, this is in respect of adverse remark, my lord, for the period.
No, he represented when?
My lord, 8 September 2006, my lord, 8/9/2006.
Is it on record?
It is on record, my lord, page 244.
True?
My lord, this representation is not on record, my lord. This representation is not on record, but the office memorandum, my lord, which I have read, that records the fact of commission of his representation.
Okay.
And that was rejected on 22 March 2007, my lord. And that is for the period 14 May 2005, my lord, to 9 January 2006. Now, my lord, at page 246 is the communication of the adverse remarks, my lord, for the subsequent period. That is, my lord, 1st April 2006 to 31 March 2007.
1 minute. For which period?
My lord, for 1st April 06 to 31/3/2007. That was communicated on, my lord, 11 June 2007.
Yes.
My lord, this was also considered and, my lord, rejected by the authorities.
Where's the rejection? He made a representation?
My lord, that's fact. But that is perhaps, my lord, not on record, my lord, but The fact that the adverse entries were communicated to him, my lord, to establish that,
No, did he make a representation after that?
my lord, that I have to. No, naturally, my lord, he made my lord, representations he made, my lord, as per the instruction which I have received. He made representation
And
against,
it was rejected
yes,
for this period also?
yes, yes.
Who's the rejection order?
The moment, my lord, I am not able to.
Did you make a representation against the communication?
Yes, my lord.
11/6,
He made representation.
2007 to
Yes,
2007?
yes. He made representation.
Was it rejected or
Rejected.
where's the rejection order?
That I do not have the copy, but they have rejected that.
Because this, all this I have to say in my judgment, isn't it?
Yes, yes, my lord.
Who is the rejection order?
My lord.
Get a copy and come back.
That's all. That's not collect a copy.
You will get it, my lord. I will just get instruction, my lord. That will be there, my lord. It will,
Well, second, etc.
Can you get a copy right now?
Lord, I will try to get it, my lord. In the meantime, I will continue, my lord, on the another aspect, my lord, because I am right now on the aspect of the communication of the adverse
So
remarks.
that's why I'm saying
No, no.
the first period. That was for
First
the
period, yes, my lord. There is a,
14/5/2005 to 9/1/2006.
my lord,
Communication was made
Yes.
according to you.
yes,
Petitioner made
yes,
representation
yes, my lord.
and it was rejected by order by,
My lord,
that is fine.
yes,
Second one also you say communication is made,
yes,
that is on the 11/6/2007.
my lord,
Now you say that the petitioner made a representation and was also rejected.
yes, my lord.
That part,
That I will get it, my lord. In the meantime, my lord, if I may proceed with
yes,
the argument, my lord, that, so, my lord, so far as this communication is concerned, my lord, it was communicated, my lord, I'll get those documents also. And my lord, now coming forward to the second point of argument, my lord, for that I would take, my lord, to page 51. There is a, my lord, this, my lord, I will page 51.
yes.
My lord, page 51 is the office memorandum dated 13/4/2010, my lord, which brought in the requirement of communicating the below benchmark grading. So far as adverse remarks, my lord, I already pointed out as were communicated and he represented and also rejected. My lord, if I may read the first paragraph, this is dated 13/4/2010. Below benchmark gradings in the ACRs, my lord has got it page 51.
Yes.
Below benchmark grading in the ACR prior to the reporting period 2008 and 9, an objective consideration of representation by the competent authority against remarks in the APAR or for upgradation of the final grading. The undersigned is directed to say that prior to the reporting period 2008 and 9, only the adverse remarks in the ACRs had to be communicated to the concerned officer for representation, if any, to be considered by the competent authority. The question of treating the grading in the ACR, which is below the benchmark for next promotion, has been considered in this department, and it has been decided that if an employee is to be considered for promotion in a future DPC and his ACRs prior to the period 2008 and 9, which would be reckonable for assessment of his fitness in such future DPCs, contain final grading which are below the benchmark for his next promotion. Before such ACRs are placed before the DPC, the concerned employee will be given a copy of the relevant ACR for his representation, if any, within 15 days of communication. It may be noted that only below benchmark ACR for the period relevant to the promotion need to be sent. There is no need to send below benchmark ACRs of other years. So, my lord, this is the subsequent requirement
which was brought in by the notification of communicating below benchmark grading. My lord, that was also communicated. And my lord, that is at page, my lord, 67 and 69. Page 67, my lord. Page 67, my lord, will find communication of entries in the ACR which is below benchmark.
This for which period?
Both the periods, my lord. Both the periods where he was below benchmark, my lord, average. My lord, will see the call in the column below, my lord, it is written with hand. My lord, 14,505
Yes.
to 9 January 06, and my lord, 14,062, 23,307. And my lord, the content of the letter reads, my lord, that the Government of India, Ministry of Personal Public Grievance Department, by their office memorandum dated 13 April 2010, had issued instruction stating that if an employee is to be considered for promotion in a future DPC and his ACRs prior to the period 2008-9, which would be reckonable for assessment of his fitness, in such future DPCs contain final grading which are below benchmark for his next promotion. Before such ACRs are placed before the DPC, the concerned employee will be given a copy of the relevant ACR. So, my lord, here, my lord, the entire ACRs were communicated to. Now, when Leonard Penn was pointing to an RTI application in the year 2011 to show that entire ACRs were not communicated. On the contrary, my lord, in the year 2010 itself, my lord, when the DPC for the vacancy year 10-11 was about to, my lord, sit, my lord, the entire ACRs were communicated to the petition. And my lord will see the date of receipt is 8 July. Next page, my lord. It is 8 July 2010. And my lord, after receipt of this, my lord, ACR, the petitioner, my lord, represented, my lord, at page 96. Now, my lord, at page 96, my lord, there is a representation against both these ACRs.
When was this representation made?
My lord, this is dated, my lord, 20 July 2010.
Where can I find it?
My lord, it is my lord, page 112, my lord. Page 112 at the middle, my lord, it is there.
Yes.
And my lord, this representation was rejected, my lord, at page, my lord, 122.
One?
122, my lord. That is, my lord, wide dated, my lord, 25/5/2011. At this point of time, my lord, one very relevant fact I would just like to bring to my lord's notice, which has not been placed by my learned friend, is that, my lord will see this is the relevant documents are there on record, my lord. My lord will see at column B, 2B, my lord, the DPC for the vacancy year 2010-11 was held on 22/6/2010. And my lord, thereafter, my lord, an additional DPC was also held. That is on 13/6/2011. So, my lord, the fact of non-communication, my lord, in respect of below benchmark is also wrong, my lord, because there was an additional DPC for the same year, my lord, vacancy year 10-11, which sat on 13/6/2011. So therefore, my lord, the communication, my lord, which I have just pointed out, that would, my lord, comply with the requirement of communication of the ACR. Now, because those were of, the communication was, my lord, made on 18/6/2010 itself, to which, my lord, the petitioner represented on 27/2010, and, my lord, the rejection was on 25/5/2011. So prior to the DPC, additional DPC for the vacancy at 10/11, my lord, there was an additional DPC. This fact, my learned friend has not brought to the notice. And his case was considered. And even before the DPC sat, my lord, my lord will see the date of the DPC, it is 13/6/2011. And my lord, that I have brought it on record. My lord will take page. Page 252, my lord.
Two?
252, my lord. Running page 252, my lord, annexure 7. My lord, see the heading, my lord, additional DPC. Promotion from assistant executive engineer civil to the grade of executive engineer civil against the vacancy at 2010 and 11. And my lord, here the petitioner's case was duly considered and he was found unfit. My lord, at page 256, at serial number 3.
Serial number?
Serial number 3, my lord. Pankaj Dixit, name is there, my lord. So therefore, my lord, the amendments, my lord, the contention of the petitioner that the ACRs were not communicated, adverse entries were not communicated. They both were communicated, my lord. So far as adverse entries are concerned, way back in the year 2006 and 7, it was communicated. So far as the below benchmark grading is concerned, the moment, my lord, the OM has come, my lord, the department has acted upon it, communicated to the petitioner. And so far as in the additional DPC would be concerned, my lord, that would amount to compliance of the requirement of communicating the entire ACR. Now, my lord, after that rejection, my lord, of the representation at page 122, my lord, which I have read, the petitioner made a fresh representation at page 121. My lord, page 121. Just before 122, my lord, which I have just read, by which the prayer for reconsideration of the ACRs, my lord. My lord, if I may read, my lord. Reference to headquarter letter dated 14/5/2011, under which an application dated 30 March 2011 in respect of Pankaj Dixit addressed to DGBR against below benchmark endorsed in the ACR received. It is intimated that while this letter number dated 18 June 2010, BBM entries, below benchmark entries made in the ACR for the period from 14 May 2005 to 9 January 2006 and 1st April 2006 to 23 March 2007 were communicated to Pankaj Dixit and for making representation, if any, against below benchmark gradings within 15 days from the date of receipt of the communication letter. Accordingly, the officer submitted his representation dated 20 July 2010. After getting the comments of the IO, RO and the accepting officer, the competent authority, after consideration of the officer's contention, rejected his representation and the same has been communicated to the officer via this directed letter dated 25/5/2011. Now the officer has submitted another application dated 30 March 2011 against the same ACR, which is not as per the directions contained in the Government of India Ministry of Personal Public Grievances and Pension Department OM dated April 2010. Since the officer's application dated 20 July 10 has already been rejected, any further representation on the same ACRs cannot be entertained. Now, my lord, against this rejection order, my lord, the petitioner preferred an application before the my lord, Itanagar bench, my lord, at page 141. Same issues were, my lord, agitated there, my lord. My lord, page 141 is the order of the High Court, my lord. And the last, the operative part is that, my lord, in the last paragraph, page 148, paragraph 11, that upon due consideration of the case in its entirety, I am of the considered view that the respondent authority should revisit the grievance projected by the petitioner to his representation dated 27/2010 and 33/2011. In particular, such examination should be initiated and completed as expeditiously as possible, preferably within the outer limit of 6 weeks from the date of receipt of the certified copy of this order. It is needless to mention herein that in event of such examination, the competent authority is of the view that grading of the ACR of the petitioner for the period under consideration requires to be upgraded. The petitioner will be entitled to all the consequential benefits flowing out of such decision. The decision to be taken should be communicated to the petitioner. Now, my lord, again, the subsequent to the Honorable High Court's order, my lord, at page 149, the consequential order was passed. Now, which is under challenge, my lord, before the court, my lord, again. So, my lord, this is the letter dated 10 January 2023. Attention of Pankaj Dikshit of headquarter 14 BRTF is hereby invited to court case number WPC 519 of 2018 dated 17 November 22 against below benchmark gradings in the APRs for the period from 14 May 2005 to 9 January 2006 and 1st April 06 to 23rd July 07. Shri Pankaj Dikshit is hereby informed that the issue raised by him in the court in case number WPC 519 of 18 dated 17 November 2022 have been given due consideration by the competent authority who had concluded, directed that no new points have been noticed on the issue and the case is devoid of any merits and the same is rejected. So, my lord, therefore, it's the my lord, third time the order of rejection was passed, my lord. And now, my lord, coming to the ACRs, my lord, which are in question, if I, my lord, peruse the ACR itself, my lord, the ACR clearly, my lord, records the fact of all the communications which I have pointed out. My lord, in the ACRs, my lord, everything is pointed out, my lord. Both the ACRs, my lord.
What do you say with the allegation that for the first ACR, first period,
My lord.
only the IO and the RO's entries were communicated and the AO's entry was not communicated. And for the second period,
My lord.
only the IO, only the IO's.
Well, in that respect, I would submit that, my lord, only the adverse entries, my lord, be it be, my lord, RO, IO, RO, or the accepting officer, only the adverse entries, that is to be communicated, my lord.
So even the IO, the AO made some entries. Isn't
No,
it?
only one of, my lord, will see the, that's why, my lord, I was pointing to page 181, the running page, my lord. That is the ACRs, my lord, which have been annexed. My lord, so far as the below benchmark grading is concerned, my lord, that is the accepting officer's final finding. below average. That requirement of communication, my lord, came in the year 2010, which we have already communicated. So far as the accepting officer is concerned, my lord, because the accepting officer finally grades him good, average, excellent. So that was already communicated, my lord. And so far as the, my lord, IO and RO is concerned, my lord, it is only the adverse entries which were required to be communicated. My lord, we'll see for the period May 2005 to 2006. Would not be. My lord, we'll see page 188, my lord.
Hmm?
Page 188.
Hmm.
Lord, it starts from page 181. Now, page 188 is the remarks of the, my
IO.
lord, IO, which says he is well educated, he looks confused, he only looks at the problems from his own point of view, overall grading is average. That was communicated, my lord.
How about the other one?
And the other one is, my lord,
RO, page 189.
no, this was also communicated, my lord, if I may just point out.
Then the next page, 190.
190 is by the accepting officer, my lord, that is the overall performance. That is communicated, my lord, that is below benchmark grading. The accepting authority, my lord, is the superior authority, my lord, above the
No,
RO.
no, here. But this, we can't read it. Can you read it? Page 190.
Both was communicated, my lord.
190, the comments given by the AO.
Hmm.
Well-educated and well-qualified officer who could have performed well. He is easygoing and lacks in practical
Practical. Positive approach.
practical and positive approach. He has not shown
Not shown due responsibility in performance of his
duty.
duties.
It cannot be
He cannot be relied
Relied
upon for
upon.
the assigned tasks and targets. Overall performance is
Adverse
average.
This
is
was
totally
adverse.
adverse.
This is adverse.
But my lord, in the year 2010, which I have pointed out, entire ACRs were communicated. Now, this is only, my lord, in respect of the adverse remarks. And my
Yeah,
lord,
this
will
is
take
for
page-
which period was this? 2000, 2000,
my lord, 5-6.
2005, 6.
My lord, that was,
Correct.
yes,
At that point of time, you're supposed to, you are supposed to communicate the adverse remarks.
that was communicated, my
Because
lord.
that OM
Page-
was,
page-
no, it was not communicated.
Page 274, my lord. Page 274. The IO and RO's remark, my lord, page, running page 274. In the rejoinder affidavit, my lord, will see. 274, my lord. Page 274, my lord.
Hmm.
My lord, will see, my lord.
IO and RO.
RO communicated, my lord.
How about the AO?
AO, my lord, that requirement was not there. But that would be below benchmark. The final authority, my lord, the accepting officer, that is amounting to below benchmark grading. That is the final grading. That need not be communicated at that point of time. My lord. It was only in 2010, wherein we have communicated the entire ACR.
No, there was some adverse remarks also by the AO.
No, my lord, the accepting officer, my lord, takes into consideration the remarks of the IO and the RO.
Hmm.
That was duly communicated, my lord. So far as the final finding of the accepting officer is concerned, my lord, that would be the gradings, my lord, the final gradings. That was not the requirement at that point of time to be communicated. It was only the adverse remarks by the IO and the RO which was required to be communicated. When an accepting officer, my lord, only accepts the findings given by the IO and RO, my lord, or he can reverse it. But my lord, the findings of the accepting officer, my lord, that is the final grading, which was not the requirement to be communicated. And in the year 2010, in fact, my lord, when the DPC was about to sit, my lord, we have communicated it entire ACR, my lord. So, my lord, the requirement of, because the accepting officer's finding, my lord, that is the final grading. That would have, because once it is accepted, once the remarks of the IO and the RO is accepted, that grading, the final grading given by the accepting officer becomes the final grading, my lord, which was not required to be communicated at that point of time. So for his adverse remarks, my lord, duly we have communicated. IO and RO, my lord, any other case also, both the periods.
Did you get the instruction with regard to the?
I have given the copy, my lord. Rejection order I have given. 2011, no. No, one, two. Oh, six, eight, twelve. No question.
This is the rejection order?
Yes, second
one.
rejection, madam.
On 31st January.
Yes.
2008, my lord.
Hmm?
For the second period, my lord. 31st January 2008.
Yes.
Therefore, my lord, the contention that the ACRs were not communicated, my lord, does not hold the field, my lord, because due communications of the ACRs were made to the petitioners. And my lord, once the ACRs, my lord, these are subjective in nature, my lord, the scope of judicial review, my lord, if I may rely on, my lord, one of the judgments, my lord, 2001. Amit.
2000?
2001, my lord, 10 SCC 424.
Yes. Para?
So paragraph 14, my lord. Paragraph 14 and 15, my lord. The scope of judicial review. Let me read, my lord.
Yes.
The scope of judicial review in such matters of assessment of merit for the purpose of promotion has been dealt with by this court recently in Union of India versus Lieutenant General Rajendra Singh Kadian. In paragraph 29 of the said judgment, this court stated as follows. The contention put forth before us is that there are factual inaccuracies in the statement recorded by the Cabinet Secretary in his note and therefore must be deemed to be vitiated so as to reach conclusion that the decision of the government in this regard is not based on proper material. The Learned Attorney General therefore took great pains to bring the entire records relating to the relevant period which were considered by the Cabinet Secretary and sought to point out that there were notings available in those files which justify these remarks. From FSI, we cannot say, having gone through those records, that these notings are baseless. Critical analysis or appraisal of the file by the court may neither be conducive to the interest of the officers concerned or for the morale of the entire force. Maybe one may emphasize one aspect rather than the other, but in the appraisal of the total profile, the entire service profile has been taken care of by the authorities concerned, and we cannot substitute our view with that of the authorities. It is a well-known principle of administrative law that when relevant considerations have been taken note of and irrelevant aspects have been eschewed from the consideration, and that no relevant aspects has been ignored, and the administrative decision have nexus with the facts on record, the same cannot be attacked on merit. Judicial review is permissible only to the extent of finding whether the process in reaching the decision has been observed correctly and not the decision as such. In that view of the matter, we think there is no justification for the High Court to have interfered with the order made by the government. In that case, this court referred to the advisory remarks both by the IO and the RO that the officer should be bold and aggressive in operation and should lead their men personally to difficult objectives. The RO has said that the officer's performance as Rifle Corps commander in the recent operation has been satisfactory, though not up to the expected level. All the reporting officers gave him above average ratings with a sprinkling of outstanding ratings. It was held by this court that the High Court was in error in interfering with the non-promotion of the respondent in that case and directing fresh consideration. My lord, subsequently, in our view, the observation made in the said judgment are apt in this case also. The adverse remarks for the period 86 in the present case cannot be said to be irrelevant matter for the purpose of consideration of the appellant for promotion as Lieutenant Colonel in his bank. So, my lord, unless there is a non-communication of the ACI, my lord, the scope of judicial review, my lord, unless there is an allegation of malafidness, my lord, or my lord, from the bare reading of the ACRs, my lord, if something comes out that, my lord, could not have been given by the authorities in a common, while applying the common prudence, my lord, then only, my lord, interference is permissible, my lord. And, my lord, the another judgment, my lord, 1991, 3 SCC 38.
1991?
3 SCC 38, my lord.
Para?
Paragraph 6. My lord. No, this is regarding the requirement of, my lord, containing reasons, my lord, while rejecting the representation against the adverse remarks, my lord. Paragraph 6, if I may read, my lord. Entries made in the character roll and confidential record of a government servant are confidential, and those do not by themselves affect any right of the government servant. But those entries assume importance and play a vital role in the matter relating to confirmation, crossing of efficiency bar, promotion and retention in service. Once an adverse report is recorded, the principles of natural justice required a reporting office authority to communicate the same to the government servant to enable him to improve his work and conduct, and also to explain the circumstances leading to the report. Such an opportunity is not an empty formality. Its object partially been to enable the superior authorities to decide on a consideration of the explanation offered by the person concerned, whether the adverse report is justified. The superior authority competent to decide the representation is required to consider the explanation offered by the government servant before taking a decision in the matter. Any adverse report which is not communicated to the government servant, or if he is denied the opportunity of making representation to the superior authority, cannot be considered against him. In the circumstances, it is necessary that the authority must consider the explanation offered by the government servant and to decide the same in a fair and just manner. The question then arises whether in considering and deciding the representation against the adverse report, the authorities are duty bound to record reasons or communicate the same to the person concerned. Ordinarily, courts and tribunals adjudicating the parties are required to act judicially and to record reasons. Where an administrative authority is required to act judicially, it is also under an obligation to record reasons. But every administrative authority is not under any legal obligation to record reasons for his decision, although it is always desirable to record reasons to avoid any suspicion. Where a statute requires an authority, though acting administratively to record reasons, it is mandatory for the authority to pass speaking orders. And in the absence of reasons, the order would be rendered illegal. But in absence of any statutory or administrative requirement to record reasons, the order of the administrative authority is not rendered illegal for absence of reasons. If any challenge is made to the validity of the order on the ground of it being arbitrary or malified, it is always open for the authority concerned to place reasons before the court which may have persuaded it to pass such orders. Such reasons must already exist on record, as it is not permissible to the authority to support the order by reasons not contained in the reports. Reasons are not necessary to be communicated to the government servant. If the statutory rules requires communications of reasons, the same must be communicated. But in the absence of such provision, absence of communications of reasons do not affect the validity. My lord, here in this case, my lord, on 2-3 occasions, the representations were considered by the department, and after due consideration, they have, my lord, rejected the prayer for upgrading of the ACRs or, my lord, removal of the adverse remarks. My lord, before, my lord, concluding, my lord, I will just like to, my lord, read few paragraphs from the ACR, my lord, to satisfy on the question of counseling, my lord, not given to the petitioner, my lord. This issue was also, my lord, raised, my lord. We'll take page 181, my lord. I will just refer to the ACRs of both the periods, my lord. The page 181, my lord, is for the period 2005-6. My lord, at page 188, my lord, you will find, my lord, at the bottom. If I may read, my lord, it is clause 23. Have you endorsed any adverse remarks? Say yes or no. If yes, give details of counseling. My lord, it is written in, my lord, very small letters, my lord, paragraph 23. And at the right hand side, my lord, will find yes. So here, my lord, verbal counseling was given to the petitioner to improve his performance. And my lord, will see page 190, my lord, thereafter. At clause number 32, my lord, page 190, my lord. At the bottom, my lord. In case any adverse entry is made, have they been communicated with the substance of the entries report, including that in the praise of the officer, indicate the letter number and date. My lord, here the letter number is indicated, my lord, 19 July 2006. My lord, that is the letter which, my lord, I have, earlier, my lord, I have read, my lord. This is also on record. And now, my lord, coming to the second ACR, that is for the year 2006 and 7. My lord, at page 199, in respect of the second ACR, my lord. Page 199. My lord, at the bottom, have you endorsed any remarks, adverse remarks, say yes or no? If yes, give details of counseling. My lord, will see there are two dates, 13 July 2006 and 31 October 2006. My lord, these are the verbal dates for counseling. And thereafter, my lord, there was a written letter also. That is, my lord, 17 July 2006 and 8 September 2006.
Where is that?
These letters are also there, my lord. at page 257. Page 257, my lord. This is the performance counseling.
This is a regional counseling.
My lord, page 257. This same letter is referred, my lord, which I am pointing out, my lord. That one is 17 July 2006. Here, my lord, performance counseling has been communicated to the petitioner. And he is informed that you, in the last paragraph, my lord, you are hereby counseled to discharge all the official duties in prompt and respectable manner to run the office smoothly. And thereafter, my lord, the another letter is 8 September 2006. September 2000. This is also referred, my lord, at page 199 of the ACR for the second period, my lord. So here, my lord, he was informed that it has come to my notice that the daily report, labor report is not been dispatched by you on daily basis. It is felt that due importance is not been given to the instructions and there is a casual attitude in timely dispatch of reports and returns. I therefore treat this as negligence on your part in the performance of your duty. I therefore counsel you to be more prompt in sending the reports and returns in time, specifically the dispatch of the DLR. My lord, and these letters, my lord, will note, my lord, these are of the year 2006. That is why I'm pointing out, my lord, because at page 199, if my lord will see, when the accepting officer accepts finally the report of the, my lord, IO and the RO, my lord, ample time is given. My lord, this letter is of 2006, my lord, will take page 201. 201, my lord. At the bottom, my lord, page 201. My lord, will find the date as 25 March 2007. So therefore, my lord, from the period of September 06 to 07, that is the counseling, appropriate time was given for him to improve. And then, my lord, the other, my lord, it may happen that, my lord, if an employee improves the performance after the counseling, the accepting officer, my lord, may not accept the adverse remarks given by the IO. So ample time is given, my lord. There is a proper procedure maintained by the authorities, my lord. And in my humble submission, my lord, as there has been no, my lord, non-communication of the adverse entries, my lord, subjective, my lord, judicial review, my lord, perhaps, my lord, my humble submission, my lord. Thank you, sir.
As my friend has, my lord, submitted, that requirement of communicating the SCR came only after the case of Devdutt. Prior to that, my lord, only the adverse entries were required to be communicated. Now, Lordship may kindly see the first ACR whereby my ACRs were adverse or not. The comments given by the reporting officer, IO, RO, and AO were adverse or not. Lordship may kindly see page 77.
Yes.
Page 77, column 23, my lord. Have you endorsed any adverse remarks? Say yes or no. If yes, give details of counseling. He ticked yes. That means that ACR was adverse. The remarks were adverse. The same opinion has been given by the RO. Average. And the next page, my lord. Page 78 is the remarks given by the RO, and page 79 is the remarks given by the accepting officer. as we have read the remarks given by the accepting officer, it is totally adverse. But these vital remarks were not communicated to the petition. Not communicated to the petition. Likewise, in the other ACR also, only the remarks given by the IO was communicated. The other two officers' remarks were not communicated to the petition. Well, the requirement, as my friend has stated, page 244. 244. The undersigned is directed to state that in accordance with the existing instruction of the department, adverse entries marks recorded in the ACR of the official have to be communicated to him for further improvement of his performance, and the official concerned has also an option to make a representation against the adverse remarks within the prescribed time limit. So this does not say the only the remarks given by the IO and RO is to be communicated. All the remarks given by the reporting officers is to be communicated to the persons whose case is to be considered.
Yes.
And this issue has already been decided by the Honorable Apex Court. If your lordships peruse the judgment at page 74 of my compilation, Abhijit Ghosh Dastidar, it starts from page 73.
1 minute. Your compilation
Yes, my lord.
page?
The judgment starts from page 73, my lord. Abhijit Ghosh Dastidar, that is 2009-16 SCC 146,
Page?
73. Lordship may kindly turn to page 74, the facts of the case. Because the relevant period of ACR will find in paragraph 2. The appellant, Mary Madam, the appellant was the Postmaster General during the relevant period and was eligible for promotion to the higher administrative grade Group A of the Indian Postal Service and to be posted as Chief Postmaster General. His claim for promotion was considered by DPC on 15/12/1999 and again on 28/2/2001. The appellant was not found eligible for promotion to the higher administrative grade A. He filed an original application before the Central Administrative Tribunal at Patna alleging that he was not considered for promotion for the reason that there were two entries in his CR, one on 22/9/1997, also may kindly note the dates, 22/9/1997, and the other one 8/2/1998. This is all prior to their death, these ACRs. And what the Honorable Apex Court held in paragraph 8, page 75. Coming to the second aspect, that though the benchmark very good is required for being considered for promotion, admittedly the entry good was not communicated to the appellant. The entry good should have been communicated to him as he was having very good in the previous year. In my case also, my lord, I was very good in the previous year, but in the impugned year, my lord, I was graded to be average. In those circumstances, in our opinion, non-communication of the entries in the annual confidential report of a public servant, whether he is civil, judicial, police, or any other service, it has civil consequences because it may affect his chances of promotion or getting other benefits. Hence, such non-communication would be arbitrary as such violative of Article 14 of the Constitution. The same view has been reiterated in the above referred decision relied on by the appellant. Therefore, the entry is good if at all granted to the appellant. The same should not have taken into consideration for being considered for promotion to the higher grade.
Yes.
So, my lord, this was related to 97-98, and Honorable Apex Court held that this should not have been considered. And there is contradictory view of the Apex Court also, my lord. So, my lord, this case was referred to the full bench, and the full bench decision was will find Sukhdev Singh, my lord. Full bench decision was will find at page 93. Paragraph 1, page 95, my lord. While granting leave on 12/12/2006, a two-judge bench felt that there was inconsistency in the decisions of this court in UP Jal Nigam versus Prabhat Chandra Jain, Union of India versus Manoj Bahadur Singh. The case basing on which the page 244 has been issued. Manoj Bahadur Singh, and consequently opined that the matter should be heard by a larger bench. This is how the matter has come up for consideration before us. Now, page 99, my lord. Because the Devdutt says communication is must. All the SCR is to be communicated. Paragraph 6. We are in complete agreement with the view in Devdutt, particularly paragraph 17, 18, 22, 37, and 41. As quoted above, we approve the same. The three-judge bench of this court in Abhijit Ghosh Dastidar, I have read the judgment, my lord, followed Devdutt. In para 8 of so-and-so of the report of this court with reference to the case under consideration held as under. In paragraph 8, I have read just now. Next. In our opinion, the view taken in Devdutt that every entry in ACR of a public servant must be communicated to him, her, within a reasonable period is legally sound and helps in achieving threefold objectives. First, the communication of every entry in ACR to a public servant helps him, her, to work harder and achieve more that helps him in improving his work and give better results. Second, and equally important, on being made aware of the entry in ACR, the public servant may feel dissatisfied with the same. Communication of entry enables him, her, to make representation for upgradation of the remarks entered in the ACR. Third, communication of every entry in the ACR brings transparency in recording the remarks relating to a public servant, and system becomes more conforming to the principle of natural justice. We accordingly hold that every entry in ACR, poor, fair, average, good, or very good, must be communicated to him, her, within a reasonable period. The decision of this Honorable Court in Satyanarayan Shukla versus Union of India, K.M. Mishra versus Central Bank of India.
That we have seen.
So, my lord, the full bench has upheld the decision of Abhijit Ghosh Dastidar, Devdutt, they have agreed. And the case of Abhijit Ghosh Dastidar relates back to 87, 88, the ACR period. And my ACR are 5.6, 6.7. And prior to that, I was graded very good. And subsequent to that also, I was graded very good. Only for that particular period, I was graded below the benchmark. And that was not communicated to me in full. So, my lord, that is required to be upgraded. And regarding, my lord, the holding of the DPC for the same vacancy period, I was senior, my juniors were promoted before communication of my ACRs. And my friend wants to say that same vacancy here, that subsequent DPC was held, my case was considered, I was not found to be eligible. And by this time, I have filed a representation that was rejected. That is not a correct proposition, man.
Okay, but I said.
Mine.
Also, but Mr. H. Gupta. CGC for the.
Oblige, my lord.
48.
Please, Your Lordship. This is also by order dated, Your Lordship, 17/5/24. Commissioner, Secretary, the Director of Limitation was directed. That's it. Director to arrest as suspend number 8 and 9. We have amended for the submitted, it is corrected. We have served the copy to the Learned Counsel, Mr. Sharma, to obtain instruction. But their name also not shown in the cause list.
Which elementary?
I think 48 is, our name is not, so it's only higher education is so. Higher education, GFM and AG and finance. I think first title was, I think that was whether it was corrected or not.
Corrected.
Have you filed your amended cost title?
Filed here. Already corrected.
Huh?
Filed here.
When did you file it?
Last week.
He had to submit a copy of the writ petition as well as.
No, already submitted. Your Lordship. On 24/5/24, I have submitted 3 copies. I have submitted Mr. Sharma, P.N. Sharma.
Let it come showing a name of the technical elevated.
Monday.
Name,
Yeah, director.
elevated.
You have
Yes.
instructions?
No, we have not, we have missed this item because our name is not shown. Only higher is shown, Lordship.
Okay, then on your request, I'll adjourn it and then reflect your name.
Element, technical elementary.
Your elementary, no,
Yes,
yes,
I am also elementary, only that will be recorded, technical elementary.
yes. But is Islam not a concept for the petition? You want some time? 60?
Yes, Lordship, let it come
Almost.
after 2 weeks.
No, yeah, there's urgency in this case. The pension matter, mother is claiming.
Let
yes.
him have some instructions.
Next week, Your Lordship, because we
On
have got
request
sub
made by
copy.
Mr. SMT, Chief Steel and Standing Council Elementary Division, list the matter after 2 weeks.
Yes, Lord.
2 weeks. List
This
is
is-
directed to reflect the name of the Learned Standing Council,
Elementary.
Elementary Education in the council.
Fix a date, Your Lordship. It is difficult to come list.
Okay, on request, man, we list the matter on to this one. 27th.
Bless.
49/50.
Your Lordship, I'm appearing on behalf of B Deca. Kindly adjourn the matter for today, Your Lordship. We have taken
Okay, on
the
request made on behalf of Mr. D. Dekal and counsel for the petitioner, in all the cases, what the.
1450, yes.
Learned Counsel for the-
4950.
When do you want?
Any date, Your Lordship.
List after 1 week.
Oblige.
54.
May it please your lordship. In fact, my lord, this matter was listed on Monday last, my lord, and your lordship has heard about the matter. Matter is regarding the, my lord, the in-charge principal of a higher secondary school, my lord. And admitted fact is that, my lord, I am the petitioner, the senior most teacher, my lord. So he should have been given the in charge principal, but instead of given to him, it was given to the inspector of schools, my lord. And that's the admitted fact. And in
Yes,
last,
you Sharma, you have your instructions? Huh?
Already scope of knowledge has been issued against him.
Huh?
Moreover, he has done his master's degree during the service period without any permission in outside the state, my lord. It is a matter of question, my lord. So,
my lord, this stand was taken, my lord, time and again, my lord, for last 2.5 months, the same stand has been taken. And on this point, my lord, this honorable court has already held that if anybody has taken any master degree, my lord, during the service period, my lord, it may be a matter for the disciplinary proceeding, my lord. And so far the degree is concerned, my lord.
It will amount to misconduct. But the decree cannot be made invalid. If provided he has got it from a recognized source.
yes. But during the service period, he has obtained a degree.
Maybe
This is the question.
it would amount to a misconduct,
Yes, it is amount to misconduct.
but you cannot invalid the decree. That would not debar the petitioner from holding the post of principal, isn't it?
In charge principal.
In charge principal.
And regarding my lord, distance education, as per my lord,
We are not on distance, my lord. We are on the, my lord, the regular mode, my lord. During his suspension period, my lord, he was suspended in 2015 to 2018, my lord. 2015 he was suspended and 2018 he was reinstated. During this period, he has taken the master degree.
in regular mode.
So far, other things have been admitted, my lord. Only that thing, my lord.
Yes.
And the
And
moment,
earlier also, my lord, honorable court asked how he got the admission and how he done it in a regular mode, my lord. And petitioner also directed to get the instruction regarding that point also.
my lord, that's an admitted position, my lord. We have already stated in our petition that during the suspension period, my lord, the degree has been obtained. Now, whether this is right, wrong, this is a different question, my lord. So far the degree is concerned, my lord, this honorable court also held, my lord, that so far the unless my lord, degree is cancelled by the competent university, my lord, degree is still to be valid. And the moment, my lord, regular principal will come, my lord, I will have to go, my lord. So till regular appointment is made, I am entitled to get the same, my lord. That's my case, my lord.
Yes.
And my lord, whether that university is, whether it is a UGC recognized or not, or NCT is a matter of question, my lord. So instruction is required on
My
that
lord,
point.
after long interval, my lord, the affidavit in opposition has been filed, and in that affidavit in opposition, my lord, no stand has been taken. And in the affidavit, my lord, what is stand, my lord will find at page 33, para 5, my lord. That is the stand taken by them, my lord.
So in this regard, my lord, to verify whether the NCT has recognized that university or UGC recognized, so NCT or UGC is required.
That is not the issue.
Petition to the president.
Yes.
He has taken the master degree from Techno Global University, Madhya Pradesh during the service period and thereafter MA in Hindi in the year of 2023 from Mahamaya Technical University, Noida.
That is regarding distance mode, my lord.
The second one.
And second one, I am having my lord 2 degree. One is my lord regular degree, the other is the distance, my lord. So far the distance is concerned, my lord, we are not raising the issue.
And distance is not recognized here also. But MA degree from the.
So what is
Techno
your
Global
argument? What
University,
is your
Madhya Pradesh.
argument?
My lord.
What is your argument?
So on some other day, maybe you know, so that I can take detailed instruction regarding the Techno Global University, Madhya Pradesh is recognized by the UGC or no?
Okay. But Mr. M.K. Chaudhary, the senior counsel. M.K. Chaudhary is
M.H. Chaudhary. M.H. Chaudhary,
M.H.
assisted by M.K. Chaudhary.
Chaudhary, Leonard counsel. Leonard senior counsel for the petitioner. No. But
Data
Mr. M.S.
collection.
Chaudhary. then senior counsel,
Data collection, huh?
then Mr. M.K. Chaudhary, then counsel. On request by Dungu Sharma, then standing counsel.
Secondary education.
Secondary education. When do you want? I'm giving a date.
After 2 weeks or 1 week.
Wait,
2 weeks. 2 weeks.
The matter on 19th.
Yes, 9.
19th of June.
No, no, highly obliged.
43.
I'm not participating.
This matter, Lordship Learned Counsel for the BPC has informed us that he has received the instruction as person to the direction of this code, Lordship. Lordship may fix this matter on 18th of June, Lordship, since it is a part-heard matter, Lordship.
This court will not be sitting on 18th.
Then 20, Lordship, if not inconvenient, Lordship.
This court is not sitting for 2 weeks. You are Mr.
N.K. Sharma, Lordship.
Heard Mr. N.K. Sharma, learned counsel for the petition.
Lordship A. Bhattakur for BTC. For P. Nayak.
You on time?
Lordship, yes, your Lordship.
On request made by Ms. A. Bhattakur, learned counsel appearing on behalf of Mr. P. Nayak, learned standing counsel PTC. List the matter when?
Any date before vacation, Lordship.
Twenty-seventh.
Yes. As part-heard, Lordship. Deeply obliged, Lordship.
55. Order.
In fact, we have already complied with the direction of this honorable court, Lordship.
May I please, your Lordship? Lordship, kindly perceive the last letter.
This has already been complied, Lordship. Direction was to pass a region order that has been issued, Lordship. And
Where's the order? Oh. 5/6/2024.
5677.
Huh?
WPC.
No. Order dated
56. Yes, Lordship.
2024.
Yes. This is the order, Lordship.
Yes, can we close the matter?
Yes, Lordship. There is nothing remains.
We'll close the matter. You can challenge this.
Yes.
Heard, Mr.
My senior led the court.
Your name?
K. Mainuddin on behalf of M. Khan.
Heard, Mr.
M. Khan.
Your name?
K. Mainuddin.
You got it? Learned counsel appearing on behalf of Mr. N. Khan, learned counsel for the petitioners. Mr. S.M.D. Chishti has produced an order dated 5/6/2024. Issued by the Director of Secretary Education, Assam. Whereby the case of the petitioner was considered. And the claim for provincialization of his services could not be considered. Has produced an order dated 5/6/20 issued by the Director of Secondary Education, whereby the claim of the petitioner for provincialization of his service could not be considered. Stop. On perusal of the order dated 5/6/2024, this court is of the opinion that the respondents have sufficiently complied with the orders passed by this court. And accordingly, contempt petition is closed.
And for respondent 1 and 3,
Oh, listen to the counsel for respondent
1 and 3.
1 and
6.
three.
56 also lordship, we have already complied with the order lordship. আমি order মতো দিয়েছিল। এই last একটু attack করে দিয়েছিলাম, last mail out of mail করে দিয়েছিলাম। Final
Order pass করেছিলি?
order pass করেছি। একটু select করে দেবেন। info এসে গেছে।
Your salary has not been, cannot be considered. Against you.
Because he was appointed in a provincialized school by the insert principal. School was provincialized earlier lawsuit and he was appointed in 2005. So direction was to whether that post, his claim was that he was appointed against a sanction claim. Non-sanction post. That was, I think ultimately it was found that it was appointed by a principal insert lawsuit. And during the hearing, no record has been, they are unable to produce any record. So let them challenge this order.
There is a direction to sanction the post.
No, there's
And
no
they are-
such that.
they are-
Lawsuit may peruse the order. Lawsuit.
Paragraph 8, page 11, my lord.
Paragraph 10 is the direction, reason order be passed regarding the sanction of post by the principal secretary in 2 months.
So this is not the same, this is not.
No, lawsuit make a paragraph 8 lawsuit make a peruse. As it is the contest under the respondent authority that the petitioner is not being paid the salary as because there is no sanction post of subject teacher in education in the Paradhara High Secondary School. And further that there are proposal from the principal of the school for sanctioning of the such post. We are of the view that it would be appropriate for the principal secretary to the government of Assam in education department to decide the aspect lawsuit and pass a reason order in the facts and circumstances as regards the necessity of sanctioning a post.
Who passed this order?
It is lawsuit.
Secretary.
It's the secretary. That is the second. Now secretary is the principal secretary post is no longer here doctrine right now. Now lordships directing the principal secretary to decide the necessity of sanctioning a post, whether it is a necessity or not, in the subject of education of so-and-so school. Once the post of subject teacher education in Paradhara High Secondary School is sanctioned, the principal secretary call for a original record for so-and-so and find as to in what manner the petitioner was appointed. If the petitioner was appointed by the following due procedure as prescribed under the rules, there would be an entitlement for the petitioner for regulation against such sanction post. In the event petitioner was not appointed by following due procedure of law, the post of sanction may be filled up by appropriate recruitment procedure. Now we have found she was not appointed by due procedure law. She was appointed in a provincial school by the insert principal only, without following any due procedure. That was the finding. Lawsuit may peruse the order. There's no mandama that she should be appointed. If she was not appointed against without the procedure, they should be filed a recruitment process.
Yes, I think we can close this.
She can challenge
You
this.
can challenge this.
My lord, before closing the contempt petition,
Dylan,
if I am
Dylan.
permitted to go through the order, my lord.
Yes.
Yeah, yeah.
She will take up the contempt petition next week, any date, my lord. In the meantime, my lord, I will go through the.
Otherwise, there's nothing. Lawsuit can close it. Take out order.
Mr. SMT Chishti, Learned Counsel, appearing for the respondent.
2, 3, and 4. There's 1, 2, 3, and 4.
1, 2, 3, and 4 submits that the respondents have complied with the order passed by this court by issuing the order dated What is this? 6/6.
Yes.
2024 by the Secretary to the Government of Assam, Department of School Education. Can we close it?
Yes, Lordship. He can,
Have you gone through?
he can go to it right now, Lordship.
Well, actually close the
But
public
I
petition,
second
granting liberty to
cancel
school
order.
disorder.
Yes.
Council for the petition. Stop. Mr. SMT Chisti, London Council, appearing on behalf of all the respondents, has produced an order dated 6/6/2024, issued by the Secretary to the Government of Assam, Department of School Education, and the relevant portion which is under 8A. Page, it's in the order. After considering the order that 6/6/2024, this court is of the opinion that that the respondents have substantially complied with the orders passed by this court. Accordingly, content is closed.
57.
Possibly grant liberty to challenge this order.
That you have the liberty to speak.
Your Lordship, I'm appearing on behalf of Mrs. R. Bora, standing counsel CBSE. Today she is out of station. Your Lordship may take it up next week, Your Lordship.
As per the office note, my lord, Lozima court order, service to the respondent number 5 is also completed, my lord. Matter we pick for admission, my lord. 87, 87.
Respondent number
5, my lord. 4/6/2024 Lozima court order, my lord.
is 4/6 or 3/6.
4/6. 57. Oh, my lord, I am sorry, I heard it is 87, my lord. Yes. I had it as 87, my lord.
Next week,
Oh, acha. No, this is regarding date of birth, my lord. My lord, understand.
You want some time?
next week, Your Lordship.
But Mr. M. H. Chaudhary and the Senior Counsel assisted by Mr. M. K. Chaudhary and the Counsel for the petition. Request made on behalf of MS. Arbora.
Standing counsel.
Let us start. Standing Counsel, CBSE. When do you want?
Next week, Your Lordship, any day.
Is the matter on?
Tuesday.
Tuesday.
Okay, 11th.
In the admission column.
Services that is.
87 of supplementary.
But in 87, my lord, as per the Lozima court order of 4/6/2024, my lord. Service to the respondent number 5, my lord.
Lavadima Court. How many respondents are there?
Basically, I am appeared on behalf of Mr. A.R. Bhuya, my lord. If all she left the court and I was asked to appear, my lord, for the office note, my lord. The respondent of 5 is only the private.
And how about the other respondents?
Other education department.
Elementary?
Elementary. 87.
My lord.
This report is completed, my lord.
Madam,
It is
come up
on
for admission,
admission, my lord.
But Mr.
M.A.I. Hussain, my lord. I don't have it.
Hussain and the Counsel for the petition. Where is the proceedings of the Lavadima Court dated 4/6/2020? Notice of respondent number 5 shall be deemed to be complete. You want some time to file a contract?
My lord.
Mr. B.K. Bora and the standing counsel. Elementary.
My lord, elementary.
Is allowed how much time?
4 weeks.
4 weeks time to file contract. Is the matter after 4 weeks? Admission call.
Probably, obviously.
58. Further hearing method.
My lord, in this case, from the petitioner side, I had completed my argument. My write-up is also there, the brief resume of the whole case. On the last occasion, my lord had asked the government to produce the guidelines for DPC. Because in this case, my lord, the DPC was not constituted for a very long time and vacancies had accumulated.
Wait, Mr. Lordship, here we have what we have obtained is the rules, Lordship, the Assam Food and Civil Supplies Service rules, Lordship. And basically what the rules say, Lordship, if Lordship permits me,
That I had placed before your lordship. The rules I had placed. Rules I had placed.
What have you placed earlier?
That write-up was also there.
Write-up?
With the. And case laws was also referred, no? My lord, list of dates. And along with the list of dates, I believe my submissions were also there. Submissions, and I think those 2 pages.
List of dates are there.
Not here. कहाँ है सब? तो है ही नहीं यहाँ पर. No. List of dates were there. Then there was a separate resume regarding the delay in holding DPC. And then the case laws.
List of dates with brief facts.
Yes.
That is there.
And my lord, I think the case laws also I had cited. So that whether my lord's notings are there or not regarding the case laws.
Yes.
I had placed the case laws.
List of dates are there. Assam Food Civil Supplies
correct.
Rules, 1970.
Right.
Then some case laws are here.
Yes.
That's all.
That's
No write-up.
no write-up. If my lord desires, that can also be given subject to whatever my London friend has got to say.
yes, it's what I got to say is that Lordship, there's a fundamental thing, Lordship. So going to tell Lordship, the amendment rules, that is rule 11 of sub rule 1 and 2, which basically says, Lordship, if Lordship have the rules, Lordship, the amendment rule.
Amendment rules.
Yes. That
civil supplies.
Yes. That sub rule 1, 75% of the vacancies in the cadre of sub inspector of food and civil supplies.
No, 1 minute. Sub rule. Rule 32.
No. Rule 11, sub rule 1. That is the amendment part.
Oh, I've just got one particular rule. Rule 32.
No.
The entire rule is the annexure itself. It is in the annexure. Rule 32 was not legible. So that is why the type of version was given.
Comes later, Lord.
But rules are not annexure. Annexure 1A. Page 25.
Yes.
Page 25 of the paper book.
Yes, CKS.
Page 25.
Perhaps this is not the amendment.
Amendment is also given here.
Amendment was done in 1989.
Rule 11, sub rule?
Sub rule 1.
Sub rule 1 is here. Is here. Page 27. You can read. I'll just verify from here.
Okay, the fundamental thing is not said. Sub rule 1 says 75% of the vacancies in the cadre of sub inspector of food and civil supplies shall be filled up by the direct recruitment through competitive examination to be conducted by a committee constituted under Rule 71. Sub rule.
How long will you take?
No, just not much, because later after satisfying your lordship, I have to get one instruction from the government also. That's why
we cannot conclude today.
No.
Because then what's the point of hearing you?
I just want
you take instructions and come back. But then 2 weeks I'm out.
Very well, below, then let it be after the 2 weeks. And since
I'm telling.
Then it's
but let him make his point so that I know what is going to argue, at least for my benefit. I want to hear him.
Sub rule 2 is basically in regard to that some inspector of food and civil shall be filled up by permission, so and so. And when we read the amendment of Rule 32, the sub rule 6, it says, lordship, that after sub rule, the interstate seniority of the sub inspector of food and civil supplies appointed under sub rule 2 of Rule 11 Sub-rule 2 of Rule 11 is basically lordship. The promotees. No. Yes, sub-rule 2 of Rule 11 promotees as amended shall be, the word here, the shall be fixed over the sub-inspector of food and civil supplies appointed under sub-rule 1 of rule of Rule 11. That means the promotees are to be fixed over the direct recruitment as amended if promotion and direct recruitment take place in the same year. Suppose yes, but in the affidavit that we have mentioned, lordship, that in the affidavit that we have mentioned, lordship, in 2012 the vacancy arose. In 2012, we have given appointment to the direct recruitment. And the promotees were in considered in 2013, lordship. So there is a definitely a period of 1 year. So upon this, if that is so, what the amended rule says, it has to come in the same year. At least because the vacancy arose in 2012. So only on this point, lordship, I want to get that clarification. What is the thing?
Lord, I have understood all this point I had argued. It seems my learned friend was not there that day. Let it be after 2 weeks, my lord, whatever instruction he wants to obtain, let him obtain. And I will make my submissions in writing.
Mr. B.K. Tiwari, Leonard Senior Counsel, assisted by Mr. A.R. Gogoi. For the petitioners. On request made by C.K.S. Barrow, Leonard Governor Advocate, list the matter of 27th of June. Okay. That day, let us try to finish.
I'm not, the guidelines for DPC are there? Because my lord had asked for the guidelines for DPC.
No, it is not, presently it's not even available.
You get it all and come. I think we can rise, no? Have a meeting. Anyway, or we can pass orders.
59.
Item 59, Lord. I am appearing, Lordship. I have completed my part, Lordship.
Unfortunately, today I'm having a meeting.
Lordship.
So we'll have to fix it after I come back. I'm out of Guwahati for 2 weeks.
Lordship. Only my learned friend has to place a citation, Lordship. On that basis,
Actually, I had a clear argument wherein they had stated something, they pleaded something which is out of the pleading.
Yes.
I wanted to place some judgments. I have got those judgments.
Anyway, today is not
Not possible.
But MS Archer.
Archer.
The petitioner also heard
if
Mr.
possible, Lordship, tomorrow, if it is possible, Lordship can be spoken. Lord,
Also heard Mr.
Deborah,
Leonard,
government advocate.
Governor Advocate. For the respondents,
Porter.
is the matter on. When shall we have it? 25th?
Lordship is coming back.
Your lordship, not on 25th, your lordship, any other day. 25th, 27th.
27.
27 is a Thursday, Lordship. Lordship.
60 to 86.
Obliged, Lordship.
My lord, I'm appearing for item number 86, my lord.
Mm.
We have an interim order that's need to be continued, my lord. They have yet to file their affidavit in opposition.
Why is it coming in the hearing stage?
My lord, because in other writ petitions, there is an IA being filed and there the pleading has been completed. Wherein with the last order, they had seek time to file an affidavit, a detailed affidavit in my writ petition. That is at item number 86.
Some cases, my lord, the matters have been fixed for, it was in the hearing list only. At that stage, my lord, they came with an affidavit, my lord. And saying that we filed an IA against an order passed by them at that stage, at the hearing stage, man. Then against that, my lord, they filed an affidavit in opposition. And the court wanted that they file an application for vacating the interim order that is passed in most of the cases, I believe. That interim order is still standing, my lord, until further orders. So if this set of cases cannot be taken up today, my lord, then my lord, the interim order will remain, and that is for further arrangement.
Yes.
That may be continued.
Any other day, Malord? Here, Malord, it says file their affidavit, Malord.
No, my lord, may I just submit him? My lord, in item number 86, in the last order, it has been very clearly stated that they took time to file a detailed affidavit in item number 86.
Yes, my lord, that they did.
Was separate order passed?
Yes, my lord, 86. Because my lord, in the all the IA, they have taken a plea of filing a affidavit only to the content of the IA. But whereas my writ petition, I have challenged the order which had come out on 18th of January.
1 minute.
No, even in our affidavit also, they said they are going to file a detailed affidavit.
Okay. Who are the parties?
Malord, I am for elementary division.
You want some time
My lord,
for filing affidavit?
my lord.
In which case?
It is NJ 39.
Oh.
My lord. In item number 80.
86.
86, Malord. Some time may be granted, Malord, we will file our affidavit.
Okay, then do I have to record all your names?
My lord.
Okay.
What may mention that the series, my lord.
Series is there.
No, no, council's names?
In this case, my lord, your case may be the motion to assemble.
Honorable.
That his name may be.
Okay, item 60, who's appearing? MSM. Heard
MSN Bora, Lord.
MSM Bora Learned Counsel for the petitioner in WBC 7232 of 2019, comma. Next item, double A.
Also for item 61 also, 60 and 61.
86.
60 and 61.
Lord,
And WBC 8824 of 2018. And
I am appearing in 72, 73,
1 minute,
76.
62, who is appearing? 1879. Then let us cancel it.
Yes, ma'am.
Heard the learned counsels for the petitioners in all the respective writ petitions. Stop. Mr. P.K. Bora,
Malord.
learned standing counsel,
Elementary division.
elementary education. Praise for
3 weeks time.
3 weeks time to file counter affidavit in WBC number 439 of 2024.
My lord.
Stop. Same is not objected to by Mr. MP Shah, SP Shah,
Yes, my lord.
learned counsel for the petition.
My lord, we have interim order.
Accordingly, list these matters after 3 weeks. Interim order passed in, how many, do you have other interim orders?
In my eye,
My lord, they came later actually.
I have
but
interim order.
In the series, my lord, where the cases are similar, identical, but there is already an interim order was there.
on 25th of January.
Even my case, my lord, there is an interim order, my lord.
Well, if our earlier affidavit will cover, then we will not.
In interim orders,
I mean,
comma, if any.
My lord, there is an interim, direct interim order, my lord, in my 86, my lord. In the first
Okay.
date of motion, sir.
No, no, others also have
Yes, yes, interim
Yes,
order
yes.
was there.
interim orders passed in the writ petition. We shall continue
Yes.
till the next writ.
Yeah, ma'am.
My lord.
No, item number 79.
So if any law has your name, any
Huh? Item, Mr. A.K. Datta, Leonard CGP,
if any law will have.
appears for the respond number
On number 1 to 9, or 1 to 3.
1 to 3 in WBC number
8226.
2226 of this.
Wait, no, no, I don't know, it's fine, again.